small and tight. Not like you. Sarah's laugh rings through the night. Such a brute, drunk and silly, thought she'd play. Crazy witch, locked me in just for the day. Life's a bitch. Can't you hear me, Sarah, please? Hook ass bitch. Out of there, my lungs, they squeeze. Let me out, you witch. This is not a funny joke. You put your hands around my throat. Feeling trapped and nearly choke. Gonna croak. Can't you hear me, Sarah, please? Hook ass bitch. Out of there, my lungs, they squeeze. Let me out, you witch. This is not a funny joke. You put your hands around my throat. Feeling trapped and nearly choke. Gonna croak. Sarah, let me out, I'm begging, please. This is stuff I'm almost begging, please someone, don't leave me here. Lost my hair, in this case I disappear. Are you there? Dark and tight, I curl and wait. Are you passed out? You'd return my face. You emptied my stash out. The game has turned to cruel. Why are you filming late? Inside I feel the fool. I can't breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as her castaway. Sarah, let me out, I'm begging, please. This stuff I'm almost begging, please. Pray someone, don't leave me here. Lost my hair, in this case I disappear. Are you there? Boom! Sarah Boone! Sarah Boone! Sarah Boone! Sarah Boone! Sarah Boone! Sarah Boone! Looking tight, I curl and wait. Are you passed out? Hoping you return my fate. Empty my stash out. Stupid game has turned to cruel. Are you feeling me? Lost it, gotta feel the fool. I can breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. Breathing stuff, I'm almost begging. Please. Drink some raw, don't leave me here. Lost my air in this year. In this case, I disappear. Are you there? Are you there? Sarah. Oh. 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 Sarah. Oh.
Good evening, everybody. We are bringing it tonight. Man, oh man, look at all you fine people here already. We've got Daniel Barry Sports Highlights. Good to see you, Cynthia. Oh yeah, Cynthia was the first. Danielle, good to see you, lovely lady. Roy Lonsinger, good to see you, man. Buck, how you doing? And we've got Roxanne is here also. Awesome. You know, we could be watching a football game, but we're gonna get through this thing tonight. And I've enhanced the audio tonight. The enhanced audio will be released, and along with that will also be the enhanced audio with the exhibits. Tonight we're not viewing the exhibits because it would take an extra hour to go through all of that crap, and I'm not going to do that tonight. So tonight, what we're going to do is we're just going to skip over a lot of those exhibits and probably run it on a little bit faster speed. Good to see you, Cynthia. And yes, it's going to be a good one tonight. This is the first day, of the actual trial. The other stuff was just a prelude to this, and so it is this tonight, and we're gonna zip through this thing really super quick. Hopefully we can keep it under like forever. Good to see you, Natalie Baker. Good to see you. And if you guys want to go back and watch any of it, I've cut and clipped most of it and edited out quite a bit. But if you're wanting those exhibits, they are there to watch. We've already seen those multiple times. No need to see them again tonight. And here we go with the stream. Man, oh man, tonight.
Win case of the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
I think I got the right one here. Did it? Yeah. Okay. It'll just take a second for it to kick in there, but it'll happen. Here we go. Let's do it. nothing I can do about the audio at this point because it's
And
jacked.
good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved
see you,
on a
Lulu.
Richardson
Good to
hearing
see you.
regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay.
Yes, it
Mr. J, have
was.
you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them deal with just billings, observations by the medical personnel, so don't necessarily apply to the issue of anxiety, as the court indicated. I did include certain pages that discuss depression issues because I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related, that may be relevant to the case.
Of those 119 images, how many are being sought? 15? Okay, thank you.
15.
State
Wow.
response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15
God.
pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that
But
at the bottom of page 25 begins her toxicology screening.
Like a forehead, but on
and
the
that does
butt.
go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues
It does.
and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted,
Jesus.
it's 0.165 grams per deciliter, over twice the legal limit.
Jeez.
It's a central nervous system depressant. We are going to have at least one medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get
Little
to that
D.
point, is also a medical doctor. She's a psychiatrist, not a psychologist.
See if you want to hang out, little D.
Will tell us that ethanol is a central nervous system depressant. I believe even the
send you an
psychologist
invite if you
will be
wanna
able to
come
get
in,
that
hang
information
out.
in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system
It
depressant.
happens.
The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
Damn.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Oh,
Page 63, it appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that.
Cheers, y'all.
So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 7th 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
yeah, you don't want to be lying
I
on
did
this
check
shit.
with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was,
Son, you done screwed up, and you're about to screw up some more. Man, don't do this. Don't do this.
one of my trips down here, I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something was mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before
You're
that she
about
was
to get
aware that they had
sanctioned.
not been disclosed.
Screwing
We provided,
around.
the copy to the state at that time.
So do these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records.
So
That's
you
why
did
we
have
request.
them.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Sanction the shit out
Whatever
of them.
date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
I may real quickly, based on the invoice that was sent from the Winter Park Advance Building Department, as a separate subcontractor, the request was made on 27th September. I suspect they waited until they received confirmation of payment of $135 for the receipt of them, so we received those. So it's all been within a couple of weeks, plus we had a hurricane issue last week, and I think they were issued to us too.
So you should have had them turned in last week.
Yesterday afternoon, after I had canceled.
A hurricane doesn't stop you from sending that information in. Man, I'm surprised that if this judge doesn't sanction him, he's being very nice. Hey, Spencer, how's it going, Tracy? Good to see you. Good to see you, Janice.
And applied to the sessions of these matters or relationship to, I was told that they already have those records. So I don't think there's any prejudice in this case.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's the purpose of this hearing, I'd like to stack the documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Damn. They're not getting sanctioned. Damn. I did fix quite a bit of the audio on this.
There was
so-
just a reference that the 31 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow
Kick
the
them out
court's
of the court.
instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's
You have a good one,
more
Lisa.
difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes, sir.
entered as one, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking
happens.
for the leeway to continue to try and search for that
Good to see
particular
you.
page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading on it. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it
Oh,
again.
of
and I'll
course.
provide
Okay. I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get.
Man, your excuses are just as bad as Sarah Boone's. Hey, JD, what's up? Good to see you. Good to see you. Good to see you. Yeah. So you're telling me that, okay, let's see. You've used the excuse that you had a hurricane. You've used the excuse that you didn't get this stuff there on time. You've used the excuse that FedEx is causing problems because just some road construction. Like you couldn't put that in your briefcase, print it out in triplicate. So you've got one for yourself, one for the defense, one for the prosecution, and then that one for the judge, for the court. Come on. What kind of shenanigans you playing? Hey, yes, homework. Oh yeah.
The copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue?
Slackers.
Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful.
gave my
The court
evidence.
finds that based on the
That's right.
positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it.
There you
But
go.
due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be
Yes.
included. For those reasons, I find that the prejudicial effect of the substantial disclosure is
Absolutely
limited.
said that.
And I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018
Yeah, those
incident
copies get
is provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included.
I just want to say that that's a really cool name, Scranton Strangler. I love it. I love the name. That's beautiful.
Anything further state before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I've seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough. But particularly with what they are seeking to introduce, given the motion to limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely...
You're talking about extra stuff coming in. Oh my gosh, what do we have here? Oh.
FBI, open up!
It's so funny.
How you doing, girl?
Good. Good.
Oh my gosh, this is crazy. Have you seen any of this yet?
Yeah, I watched some of it on Baker's channel. It is pretty crazy.
Oh, this stuff right here is killing me. I'm just like, damn.
Yeah.
Judge, you have to declare mistrial because when they opened the suitcase, George was not in it.
God.
It's awesome. I love it.
Prejudicial, dangerous, and
Oh,
to use
yeah.
Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Oh, yeah.
Judge, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to.
But you can't submit this shit until she actually testifies. Like you can raise this at the opening arguments, and the judge already said this shit. Like this guy must not be getting it, and he's just doing it intentionally. Hey, Yamaha, what's up? Little D, meow. Yeah, he's checking out that hair, little D. He's like, meow, meow, meow.
That's funny.
You give up? Have fun? Oh, why are you giving up? What happened? What happened, Tammy?
Some of these things are like, I can understand, like some of it is hard to follow, like especially if you have ADD like me. It's like, hold on, what's going on? But
what's happening here is they're trying to use exhibits that are going to be displayed throughout this whole trial. Okay. And in those big boards that they're getting ready to bring in, and he's just sitting there going, yeah, you can't have those because one, those are not proper jury instructions. And two, these are just not correct because one, she has to testify before you can promote self-defense. Like you can say it in your opening statements, battered spouse syndrome or whatever it is that she's claiming. You can do that during your opening arguments, but until you have evidence, you can't submit this. True. And he's trying to submit it as evidence, and the judge is about to lose his shit on him over this.
Sure.
Put on a case involving self-defense, and under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are.
Oh
Evidence of prior threats or prior events of violence committed under that instruction, under the self-defense.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney.
That's what you said.
We rolled up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in consider the verdict. You read it out?
No, I can see it, sir.
Oh, I can see it, but they're not allowed, you dumbass.
Possible doubt, speculative, imaginary, or forced doubt is the standard instruction on using it.
What's your position with regard to those two, Mr. J?
Judge's opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Exactly.
Doing this 35 years, I've had these boards, I've used these boards in opening statements, I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this.
Well, you son of a bitch. No, judge needs to say, no, you're not bringing those in. I don't want
He's insisting on those fucking boards.
No, he is because here's the thing. Those boards are not correct. Those boards are not correct. And he should not be introducing those because he's introducing them as evidence. And most likely the judge will say, yeah, you can't bring those boards. If you want to bring them in during your closing statements, go ahead.
Yeah, but not during. That's why I said, why are you discussing law during opening statements? Like, come on, man.
Right. He's like, oh, I brought these into courts before. And it's just like, yeah, but you're not bringing them into my court, asshole. How about this? You've got them sitting in front of the desk. So the jury is seeing this the whole time. And I would say, no, those can't even be displayed. It's like assholes.
Weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction.
I guess 35 years ago, the shit's changed. You might want to change your placards. Get the fuck out of here.
Yeah.
Those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as it, I mean, we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
This is an excerpt from the way
It's an excerpt. Get it? He is really all about his little boards, isn't he? And,
Yeah,
and
he
Judge
sure
is
is.
like get this shit out of my court.
Yeah.
I bet this guy.
That's like the
I bet this-
DoorDashers with their phones when they come into my work.
Yeah, I bet this guy. Yeah. Look. I am special. You're special, all right. You know, here's the thing. 35 years ago, this shit might have worked, but yeah, I don't care how long you've been practicing. These aren't going to fly in my courtroom. That's what I would be telling him. Like you're not going to taint my jury. Hey, how's it going, Taz? Tay's auditors laugh like hell, but the judge, they're placards. Don't care. Get him out of here. You should have collabed with Baker. His boards are much better. Yeah, I agree. Yeah, you should have done that. God, this guy's doing.
Give me a moment.
That's all they're doing is playing games with this. Oh, bastards. And that they're wasting time on this crap too. The judge is like, no, just get that out of here.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law. When we're just talking about opening remarks, 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Yes.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, you know, that in many ways we do it where we give them the law at the very end, you know, and.
Sounds reasonable to me. Like, how about this? Listen to all the evidence and then apply the law after that. I mean, I would say the same thing even if I was defense. I'd be just like, yeah, I mean, the law only applies till after you've stated all the facts and then how you apply it to the law. You don't need to have this shit. It's just clogging up the courtroom.
I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate.
I think they already know.
It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
Just tell them no.
I think for the record, we should mark them.
Okay.
He's got another board.
Do you want them marked? You want them marked by Madam Clerk, correct?
Good Lord.
Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
He spent more time making these freaking placards. Dipshit. Skipping forward. Waste of fucking time.
Taking that much time.
Yeah. Yeah, smile now, Sarah Boone. You're about to spend your life in fucking prison.
Yeah.
All right.
You know how many of these things?
It's like, Jesus Christ, I thought I edited all this crap out of here. Here's a diamond art, Your Honor.
Identified
That's awesome.
is A, Defendant's Exhibit A. This is of a demonstrative aid and opening statement. There's a picture of Sarah Boone that was taken by law enforcement on one of the incidents involving arrest.
Is it a picture of her taking a dump on a toilet or something? I don't know.
Her swatting the bush. Did you see that?
Okay. Next one.
This is the townhouse in question with her 2 dogs.
I don't know if I want to see a picture with her and 2 dogs.
Blow up a picture. Glass door.
They're trying to make it seem like she's all sweet on him, and oh look, they were in such a happy relationship. Yeah, why don't you show the like baseball bat marks the side of each side of his face? How about that?
Yeah.
You know, if you want demonstrative, you know, the prosecution could have easily pulled demonstrative. Yeah, this is what George looked like after he got the hell beat out of him by Sarah Boone. I mean, I would throw all this crap out. Suitcase.
Yeah.
To Sarah Boone's left arm from George Torres.
It's all night making these placards.
There's a close-up of the wound to Sarah Boone's leg where George Torres stabbed her with a steak knife. This is Exhibit G.
I don't know why I drink
There's
so
a
much.
close-up of Sarah Boone's face. And it shows where George Torres poked her with her paw.
His head is so shiny.
Then Exhibit H. There's a photograph, close-up of Sarah Boone
Oh,
after she
Lord.
was kicked in the head by George Torres. Then Exhibit I. Here's another close-up of Sarah Boone's face after she stuck a injury with the hands of George Torres. All these, I believe, Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had the photograph. The state provided the defense in discovery of these photographs. We intend on introducing these photographs. We don't intend on introducing blow-ups. We intend on introducing the home-size pages of the photographs. And then using these as demonstrative today to show the jury the
Throwing pictures on his head.
injuries that Sarah Boone sustained at the hands of George Torres.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens,
Yes, sir, Judge, I sent you some pictures.
when did you send it, sir?
This morning.
Oh my God. Is that guy barefooted over there? You see
I have not
that?
received it.
That's a lady.
Oh.
She's wearing she's not barefoot.
Oh.
They're just flesh-colored shoes. Right there.
Imagine. Yeah.
I think Judge, we're already on the bench, so we sent it to the clerk and the jail.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
This is just these 2 cases. Been provided Alsaguer v. State, 326 7th 3rd, 656, Florida Supreme Court 2021, Lowe v. State, 259 7th 3rd, 23, Florida Supreme Court 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case, which is the 2021 case, trial court acted within its discretion in preventing state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record.
Move the camera. Stop moving the camera.
The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin and a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation.
It's completely
The mannequin was
different.
used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the ink.
So here's a question. If that's what you're going to say, you need to have as demonstrative. Well, then why don't we have George zipped up in a suitcase as he's pushing up against it, trying to get out, or maybe and have the baseball leaning up against it, the baseball bat leaning up against it. You know, maybe just have his body laid out there. You know, for demonstrative. How's that, you little asshole? She's coloring blood.
Incapacitating nature of each gunshot wound, advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, court's discretion. As you know, we're claiming self-defense.
How's that?
And as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm.
Her state of mind is different from the norm. I agree. Yes, I am drinking something good.
Take the two instructions and read.
Diva
Sarah
had,
Boone, because of prior threats or difficulties from Jorge Torres.
Well, you froze up. You froze up. You're all frozen, Daniel. You'll be back in a second. What happened?
there we go.
Yeah,
Did
what
you hear what
happened?
I said? I don't know what
No,
happened.
you said you have.
Oh no, I said Diva had peanut butter and jelly beer the other day. I thought that
I
was
know.
interesting. I don't know
Yeah,
hopefully my computer's not messing up. I don't know.
No,
I
you're
don't know what's
good.
going on. Okay.
Yeah, she was not feeling well after that. Oh, her state of mind is special. That's special, correct. Her state of mind is very special. Now, Judge, I'd like to discuss the Schoolhouse Rocks. Y'all need curly.
Had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of Jorge Torres. You may consider this fact in determining whether the actions of Sarah Boone were those of the
You can, and the judge has already ruled on this, you dumbass. The judge has already said you can discuss this in your opening statement, but until she testifies, we're not going down this path of having this crap admitted. Oh, Jesus.
reasonable person. Goes on to say, if you find at the time of the alleged second-degree murder, Sarah Boone knew that Jorge Torres had committed an act or acts of violence, you can consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use one of
She needs to have like big, you know.
You have good faith.
Something.
If she had some hair, it would make her look fatter.
Yeah.
They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of
With
their
the
history.
baseball bat?
Thank you. Any response, State?
Yes.
Yes, sir.
Yeah.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and that it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture.
On the whiteboards.
If a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. I don't know. It wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in open. Remember that?
No, what I ruled is that you were able to discuss them. You address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties.
But you
prior
haven't
acts of
brought it
violence
in yet.
is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there's going to be evidence of an overt act.
Good.
That she was facing imminent
Until
threat.
it's brought
She
in, you
reacted
can't have
based
it.
on that threat.
Understood. Your response to Exhibit B?
Look at B. Which one's B?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, your story is abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want introduced, that they listed as exhibits. I thought for sure we put this on there, but
What's the exhibit
the
number?
relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking, Judge.
All right.
On whether they have
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend
Yes.
to play the 2-minute suitcase
Okay.
video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach the bench on that.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose, it's good for the gander. It's not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through a demonstration and publication after that evidence is admitted. Y'all can approach.
There we
While we
go.
approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you. Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense. All right, let's stand and bring in our panel. Good morning, y'all may be seated.
Yo. I cut it out. It was a long delay.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yeah.
Can the parties approach for a moment? All right, members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. And then you have not conducted any independent investigation regarding those items. You just raise your hands to confer you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you approach for a moment?
Oh boy.
And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir?
Is that really the
Mr.
suitcase?
Owens. Okay, thank you. All right, thank you both for your honesty. I appreciate that.
Well,
Something we talked about
suitcase
earlier this week.
is
That's the
in
one
the
thing
courtroom,
that we
but I don't
require
think
and
it's
ask of
in
you is just be open and honest. And I appreciate both y'all's
To be too
open and
small.
honesty. During the ride in the elevator, was there anything that you saw or observed that would impacted you or influenced you in any way? Did it have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him, and then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. And out of conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah. "For everything you've done to me." Sarah, fuck you. And then the defendant laughs. Sarah, fuck you. And the defendant laughs. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't fucking breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, Sarah, Sarah. The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in the suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is put into this suitcase left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see Jorge anywhere, Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Hears gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out and gurgling. The next thing she does is she will call 911. She calls Brian Boone. Brian Boone. Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. It's a normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, they'll co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Mondays and Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. Now he's led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her and calls her and calls her. And then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, about 10 minutes. And then she's explaining to him what the heck is going on. He peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right. There's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though, being the good co-parent that he has. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late, he's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible, this is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies, his deaths, was taken to the 9th District Medical Examiner's office in autopsy. And what the doctor found was what you would expect after being left in a suitcase, crumpled out in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, he suffered from blunt force trauma on his torso, in space, his mouth. She'll use words like contusion. We'll help her explain contusions and bruises. She'll use words like hematomas. We'll help her understand for you all that means bleeding under the skin and blood, what you expect to improve. That's why they're running blue. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body on camera. And it's more of the same as what we heard on the 911 call. I see. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of the counter that was found at a suitcase in Mr. Torres and giving it to one of their digital forensic examiners who we'll hear from later in the trial, no alarm. But it's time to give the first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Bohr wasn't even half full, so the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect of a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, the equivalent of 2 standard bottles of wine.
Jeez.
Holy crap. I did not know that.
A lot of
Those
wine.
are some big bottles. Like that's some cheap stuff too.
Yeah. That's the kind of getting messed up quick though.
Well, that's the purpose of them, just to get you messed up. You're not drinking for the flavor of the wine. You're drinking just like we're talking like $7.99 at whatever local grocery store or whatever.
Or gas station.
Those are 1 point. Oh my God, that's like twice the amount. So if they finished off a half a bottle, it was like her drinking an entire bottle. It's like them splitting an entire bottle and then finished off another bottle after that. Dude, she was trashed. $5 Chuck.
But she didn't fall asleep. She passed out.
Passed the F out. Yeah, damn right. Oof.
A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74.
Yep.
And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price.
Shit.
And those two bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So
No,
that's
those
the
aren't
context
Magnums.
that we're dealing with when we hear things like, we only had one
Well, they
bottle of
might be
wine, and we
considered
finished with what was
Magnums.
left in the
Magnums
bottle
are
of
much
wine
bigger.
from before. Well, ladies and gentlemen, there's two 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine.
Yeah.
So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for
Yeah,
his
100 for a
little
man is
fingers
tiny.
to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. Two little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine.
Damn.
And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean the Orange County Sheriff's Office, in part, is going through the phone. That's when they discovered the two videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself.
How'd that work?
Then she
out?
gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped them over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there.
Oh, man.
When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happened before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
Oh, she'll be in jail.
What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh. Torres. Referring to Mr. Torres. Getting rid of.
Well, and in her defense, I will say that's probably taken out of context.
I think so too. Yeah, that's what I thought.
Yeah. I would say that's taken out of context. I would say that's more like, yeah, I'm gonna boot him out. I'm gonna get on with my
Yeah, I'm
life
getting
and get
rid of
away from
him. Yeah.
Yeah,
Getting rid
I
of
don't
him,
take that
moving
as
on.
malicious.
Yeah.
But this is why you have to be careful the kind of shit that you text and
That
you
you
talk
say.
about.
You're right.
Yeah.
My
Because
aunt
they
said
can take
always,
that.
always act as if you're in front of a judge, like with any decision you make, think about that.
Yes. You should totally draw a robot on the box. That would be, I should totally do that.
What is
Let's
in
see,
that
should it-
box? Do we know?
What's in the box? Well, let's see. I think in the box, it's got to have the, the mouth with, the screened. Yeah. It's a happy box. What's in the box? Well, it's screened in here. And it's got its little eyes. It looks a little bit like SpongeBob, doesn't it?
A little bit.
Yeah. All we need is like little holes here. It's a SpongeBob square box.
Kenton said Sarah's wine glass. Yeah, for real.
No, he's got his wine glass. He's got the wine glass here. It's more like a martini glass. He's just like, cheers, y'all. Woohoo! I'm partying, man. Party box.
And that's the case. That's what the evidence is going to show. But We, the state of Florida, and the members of the jury in our journey to this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door you shall not enter without permission and invitation. Halloween's in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Why? Let's say during this trial.
What?
We're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we're going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony to be. And he made her curl up in a fetal position on her own porch for 4 hours. And she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who had serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and the same time, other things that I expect could possibly come in. Despite that first.
Holy cow! Look at you. How's it going, hottie?
Right?
Melissa Jane. Good to see you, girl.
Yay.
Doing, man. I haven't seen Melissa Jane in a while.
You
I
missed
need to get her address again. I've got something to send to her. Doggone it.
Despite
It was 3.1. He was wasted. That's a lot of alcohol. It has been a while.
at that point in time of this first date, not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship. It's one thing to have a bad first date. It's another thing to end a 25-year marriage.
So imagine this shit. So while she was married, she was out bar hopping, hooking up with dudes, hooking up with chicks, bringing them back at all hours. They would show up at her house, harassing her husband. Where's Sarah? Oh, yeah.
Whoa.
Yeah, that, I don't know if they're going to bring that in, but found it. Diane G brought in the 5 gifted memberships. Holy hell. We've got Wishful Wen got gifted a membership. Scranton Strangler was gifted a membership. That's such a cool name. Cynthia Nollner got gifted one. K Matt Red Queen and Cynthia Fire Fairy was gifted a membership along with Hey Joe. Oh my gosh, that is so awesome. Thank you so much. Here, I'll give you this. How's this, Diane?
Oh, kid. You're an angel. Show me your boobs and I'll let you borrow my bike. Boobies.
I love that.
That's so awesome. Thank you so much. Thank you so much. Yes, congratulations to everyone that got one. That's beautiful. Oh man. No, and whenever they, and I mean, I don't feel bad for the husband in a way, because he is sort of a cuck. Just saying, if you listen to him talk, you're like, you're sort of
The ex-husband?
Yeah, the ex-husband, because he knew this stuff was going on and he wasn't like putting an end to it. It's just like, no.
And they share a child together. Like, you know, the kid's like my son's age, and it's just, you know, they're so impressionable at that age, and it's just sad that he has parents. The dad seems more present than she does, but you know.
Yeah, the dad. No, I'm saying he is completely present as far as I can tell, but
given
it's
him
still
somewhat of a normal life at least.
But he's still just a bit of a cuck. I mean, dude, if my wife showed up and there was people randomly showing up and like, hey, you know, where's your wife? And be like, who are you?
Yeah.
And the first time I'd be just like, what's going on? I would ask her about it. And if she was like, well, I've been hanging out with these people, I'd be like, okay, so you're hanging out with these people. What's going on? And if I found out that there was,
home.
yeah, that there was, if somebody was bringing someone home to my bed or even outside of my, like,
Yeah, it's
bye.
invasive. It's weird. That's probably why he's not with her anymore.
Well, part of it, and also she could, whenever she would drink, he explained this. He was like,
drinking.
whenever she drinks, she doesn't stop. Like she drinks
that's an
until
alcoholic.
until she passes out, and then you know, he could only deal with it for so long, and then he's just like, all right, see you, bye. Been following this and Mo and Broken Baker. Oh yeah, this is.
Same.
I've been covering this since the first bit of this came out. It's been months since
Me either.
well, hell, I want to say it was 2022 whenever I first started following this.
Gosh, yeah, that doesn't seem that long ago, but it is, right?
Yeah, time flies.
Time
It's just
yeah.
like not much has been happening since then. Your comment got put in between the new membership. Oh, okay. Sorry. That's boobs. Yeah, I like boobs. Boobs are awesome.
We all love boobs.
Despite that first date, there's a second and a third. Now these days are at a bar, and there's nothing wrong with that. But, and it just typically ends up, she's going to tell you what to suspect, or you're going to hear that she said one way or another. It's one thing or the other. Like I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview, happened about a month before this. Bloody ears, a stab wound in the leg.
You hate boobs. They give you black eyes when you.
Yeah, your own would be annoying. So I get that.
I was in during my AIT, which is the schooling for the military. So because we had males and females. It was like I think the males were on the first. Is that right? Females might have been on the first floor. The males were on the second floor and the third floor. And that we had this girl that was very, very well endowed.
Yeah.
And they put her at the very front of the runners because everyone would get distracted whenever she would run because it would just be bouncing. And it was like, oh. Well, and her and I used to hang out because everyone would be hitting on her all the time, and we were both buds from New Mexico because I think she was from Albuquerque, if that's right, Albuquerque or Santa Fe. So we would hang out all the time, and we would actually, whenever we would go off base, we would share a room together because she was just like, I just need to have a safe place to come back to because she goes, I know that you're not interested in me.
Yeah.
I was like, yeah, like you don't
it's
do
always
it
nice
for
to
me.
have one of those guy friends.
Yeah. Well, we were just like buds, like that we would hang out, and when she would go, and she liked to go dancing, which that wasn't my thing. I just like to go and hang out and drink. And yeah, or go catch a band or something like that. But whenever she would come back, she knew that she had a room. And we had like a code set up. So if she was hooking up with somebody, she would just hang something outside the door, which meant that she had a guy there not to interrupt. And so I would just like leave until like it was gone. But that's how you got to do it. 69. Ooh, nothing wrong with 69, Diane. Just saying. We keep it at 70. 69 is just fine. 68, and I owe you one.
Which was perhaps described as sword fighting, playing around in that way. But nonetheless,
Sword fight?
I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this witness comes in, the state is going to have the opportunity to take lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 24th. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room, labeled the defendant and the victim.
But you know, the best, you know what number is better than 69, Danielle, right? 88. You know why?
Why?
Because you get 8 twice.
Past relationship. I suspect there's a chance we may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized, the experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5 Diagnostic Statistical Manual, version 5, and I think it's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder diagnosis, it'll say, well, all of us agree that it needs these 3 elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Give you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts, because it's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over on an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into, at the end of the day, after we talk about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society. Years ago, when this was first being researched, the question would be, well, why don't you leave? And battered spouse syndrome and the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, the isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction. That's what it's used for. It's not used for explaining the subjective belief at one point. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape, I rewired the entire thing, brand new JDC pipes, this sucker's good to go. I agree with this, isn't that? You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things that the Fox, I'm here, the Carfax does. You want an expert to get reliable information. The expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient or the client that is saying all these things happen to her. You gotta find proper information. You gotta check reliability. Particularly in circumstances that we discussed in the case. So another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that testosterone applies. Some people can go home and fight like cats and dogs. And that's just their day. They get over it. They live their life and find another thing. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harkin said it applies to the school. But we'll talk to her about what she relied upon to make that conclusion. We'll talk about some other things and take that hearing together and get there. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule sequestration will be invoked. Thank you.
Oh, yeah. Oh, boy. Now
You may
we
proceed,
get,
sir.
now we get the defense. Yeah, she called her a horse. I thought that too.
My name is James Owens, and I represent Sarah Boone, along with Cole Henderson and Kevin Miller. Now, this is going to be several days long. Obviously, today, maybe Tuesday, Wednesday, we're not sure. But we're trying to make arrangements for witnesses upon expert witnesses upon and we'll know more probably within the day, maybe Monday, so we can plan. I know your focus is on this case because you took a note. Ladies and gentlemen, there's no higher call than to write a note. No higher call than to write a note. And we're going to ask you again to write this note. We'll find Sarah Boone not guilty because she was justified in the force that she used to defend herself. If that force was reasonable.
I don't know. She's justified the force that she used on herself, like where she hit him with a baseball bat while he's locked up in a suitcase.
Yeah.
Yeah, just saying. Now, oh God, he's gonna do his show and tell. Yeah.
Oh,
He is-
yeah, I forgot about that.
Oh, yeah.
Under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone.
Did he really?
And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years. And there were several prior incidences of violence. We've got the photographs. There were incidences where police were called. We took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had, and considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of these larger bottles of the wine. And then, of course, there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how will those resolved, really?
Well, and their disagreements and their way of resolving crap was not good. Just saying. Like, I've had arguments with my wife before, but they've never resulted in either one of us attacking the other person.
Yeah. It's a toxic relationship.
Yeah, theirs was one of those where well, I'm glad someone thinks so. It's funny.
And it's alcohol induced, so
yeah. Well, and you know, it's one of those where I'm sitting here watching the way that, you know, especially whenever she, you know, because I've got videos and that I've uploaded of her, you know, coming out of her apartment completely trashed, and you know, wanting to be all touchy feely with a cop, and these cops like, no, we're here to arrest George because, you know, you called the cops on him because you guys were having an altercation. And she was just like, oh, George, I'll get you out. And then turn around. You've got both of them being arrested by the police because they're attacking one another. And the cops are just like, we're just taking you both to jail. And then there's other times that she's been taken to jail for attacking him. So she was giving just as good as she was getting. She also outweighed the guy by, I think it was 20 pounds. I mean, she's, you know, as thin and as skinny as she is, she's still throwing down. Like, yeah. I mean, the amount of aggression between these two is so bad. I've had roommates that would do this kind of crap where they would just come out and they'd just be yelling at one another. And it's just like, what the hell is going on? It's 2:00 in the morning. What the fuck are you guys doing? And I told him one time, I was like, listen, I want to lock you guys out of the fucking house, and I want to call the cops and let them sort this shit out, because I'm sick of this 2:00 in the morning when I've got to get up like in 5 or 6 hours, and you guys are out here arguing over some bullshit, and who knows what the fuck it was about. Yeah, 35 pounds. Back to polishing your bone, Buffalo. That is purrs. Bad Duck, that's an understatement. Hey, Bad Duck, good to see you. Howdy. Hugs. Giving those bear hugs is what he's doing. Duck hugs. Gotta be careful those duck hugs, man. Get you with a corkscrew.
That's what this is about. Our disagreement was that. But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone. or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money. But they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine
Man,
bottle
lost the
was
hair.
gone.
Bad duck likes your
And
hair
George
there,
had said, I
Danny.
want to go
Yeah,
get
I
some
see that. I'm messaging
So there's a
him.
convenience store
Sure.
right close by their apartment complex, and Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and you'll be able to
That's
see
3 bottles
the
then.
purchase of that bottle, and then maybe that bottle will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication.
Well, and here's the thing: if she knows, and she's saying she knows that he's going to get to that next level of intoxication, at that point you remove yourself from the situation.
Mm-hmm.
But that's not what she did, because the video will show that she says, "Oh no, we just kept playing. We were everything was good. We're not having arguments. We were playing cards and dominoes, and we were having fun. We were drawing pictures, and then we were playing hide and seek, and it was all fun." Except she is more trash than she should be.
Mm-hmm.
Mm-hmm. Yeah, it's he's trying to spin the story, but he's a horrible spin doctor, I will say.
Yeah.
Yeah,
Agreed.
twice a week now you've been unable to chat in any live streams for like 24 hours. Well, Bad Duck, I haven't removed you from chatting here. The only reason that you wouldn't be able to chat in live streams is if you put in a word or something like that they don't like, and it's YouTube. There's nothing that these channels are doing against you. It's something on YouTube. This lawyer should have just stayed in retirement. Yeah. This
And then his boards.
Yeah, with his
Poster boards.
So Sarah's concerned. So attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated.
Hey, Daniel.
At a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point she gets cold, she gets tired, she wants to go sleep. Well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat
That
it.
suitcase does not weigh 100 pounds.
Malnourished to a large degree.
That suitcase does not weigh 100 pounds. Now, both of them combined might weigh like 200 pounds. Yep, I know it's no creators or mods. It's just deal with YouTube itself doing it. Yeah, they don't like the Bad Duck. I don't know why.
Yeah.
But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it, and that's how they move back and forth. Well, she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And
how's he going to spin this?
they carry on. She sits on the couch, and at some point he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opening. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what.
Doesn't matter.
But he's a captive of
Yeah.
hands.
If they're
Physically, they're the same
legitimately
size,
saying
but
hide and go
he's
seek,
much stronger
wow.
than her.
Yeah.
If they got in a fist fight, he would win
What's up,
100
Zach?
times out of 100. But she's got him now. He claims he can't get up.
Hey, Tinkerloo.
He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch. She turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George is, the suitcase is flipped upside down. The zippers are off. 11 minutes later, Sarah has flipped it right side up. Again, open for
Awesome,
him to get out.
Tinkerloo.
And it's only 22 seconds.
Cheers, Tinkerloo.
And you hear George say Sarah. And that's it. Now, the key to the case is that 11 minutes.
That's not it.
And what
There's a lot
happened
more.
during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took
No.
to
No,
prevent an
absolutely
attack
not.
from George Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense.
She was justified. They wouldn't have put her in jail to begin with.
Yeah, because she didn't claim self-defense in the first place. You know, there's
Right.
one thing if you say, listen, you know, I put him in the suitcase because I was afraid he'd get out and beat my ass, so I was sort of letting him sleep it off a little bit, and then I went upstairs and went to sleep. That's not what she says. She says we were having fun, locked him in the suitcase.
No, you didn't
I went
mean it.
upstars, I passed out and went to sleep.
Wasn't
It's like-
intentional.
Yeah. She says it wasn't. I had no intention. This was not my fault. And just like ooh.
Yeah, she's one of
Just-
those.
Yeah.
Him saying she's justified is just irking me.
No, I know you're not.
You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe.
What?
And that changes things a little bit, as the medical examiner will explain.
No, he was not deceased whenever she was beating on him with a baseball bat. He was still alive. Okay. Yeah, this hey, turn that frown upside down, girl.
I must be really
There's some
concentrating.
bruising. Sarah's going to
Yeah,
explain that to
I'm
you.
concentrating too.
Why that happened. What were the circumstances surrounding that? Involving the bat. Her son comes and stays with him from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it.
Because he couldn't do it in one swing.
And it's during an argument. And he's trying to intimidate her.
Doesn't matter. Here's the thing that people fail, you know, and there can be people that are sitting there going, well, it was justified because he was violent. Here's the thing. And this goes way back, and I don't remember the case. There's smarter people than me that could probably quote what it was off the top of their head. Okay. The case is this guy comes into a bar, threatens somebody, and you know, pushes them around, gets physically into an altercation with them. The guy that was threatened goes out to his car, gets a shotgun, comes back inside and blows the guy away, and then claims self-defense. Okay. The thing is, as he lost, obviously. The thing is whenever you've removed yourself from a situation where somebody is being abusive or aggressive, remove yourself from the situation. There's no threat of imminent harm. There's no threat of imminent danger. At that point, you can't claim self-defense.
Yeah,
and that's
out of the
what
question here. Yeah.
So whenever she says, whenever they say, well, she did this, this, and this, and this, and she was worried that he would come back up, and this is why she's claiming self-defense. All she had to do was leave the damn house. But she didn't leave the house. She could have called.
Instead of doing this whole tit for tat thing,
Yeah. I don't think it would matter which way this went, accident or self-defense. She's going to be found guilty. She should have taken the plea deal, period. Absolutely. And I saw a little bit of this later on where she says the judge asked her, are you satisfied with your counsel? I was like, I don't know what led up to it, but I was like, holy crap. Are they doing that bad of a job?
Sarah loved you. You're going to hear why women don't leave. Why women don't leave. And you're going to
she
hear
did
about
leave. She left him
Sarah
in the suitcase
Boone
to
and her
die.
struggles. Her mental health struggle.
Yeah. She is a danger.
Sarah had no intent to kill. The prosecutor mentioned she wanted him to die.
I'd much rather have tit than tat, just saying.
She hated the abuse.
I felt like a bad trade.
She tried. She tried kicking him out 6 or 7 times.
But it was his
He kept coming
house.
back. She changed the locks. He kept coming back.
And she would keep letting him in.
She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all.
She couldn't hold a job down because she was just...
You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship.
Yeah, the only thing that you have to take into account as a juror was what happened at that moment. You can't take the prior acts. You have to take what happened at that moment. Her actions at that moment should have her behind bars for the rest of her life.
Mm-hmm.
There's no excuse for that. The second counsel during the last motion hearing was really bad, and the two attorneys seemed to not like each other during hearings. Yeah.
Now you can
Good
find
to
that
see
Sarah's
you.
not perfect.
Red Queen.
And, she goes, as many of us do when we drink too much, and you sleep in. She slept in. 11, 12, 1, somewhere around there. She moses downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees a suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house, and their son is at it, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger.
That doesn't mean
Smart,
shit.
but she's not
not
moral.
Yeah,
smart.
I'm close to my ex-husband,
She
but
calls, Brian, what do I do? He said, I'm coming up. Please come up. He's about 5 minutes away.
Yeah.
And she calls him
Yes.
again within a couple of minutes. Yeah, I'm on the way.
really
He
drives
gets
that
there.
man crazy.
He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. They got the body cam now, so it's recording. So you're going to hear Sarah talking. But Sarah's freaking out.
She's
Sarah's
saying
thinking,
never does she claim
and
self-defense.
I'm somehow responsible.
Yeah, she is.
Eventually, she gives a statement to law enforcement. She gives one to Detective Deputy Rodriguez. She's not the homicide. She's just responding. She's the first responder. And they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars, and it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it, take out all the data, all your phone calls, text messages, photographs, videos, all of it. And they find these two videos. Sarah's not aware, she doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective.
Dude was in a suitcase for probably close to 12 hours. Okay, if that gives you any idea of how long he was in that suitcase. I mean, think about that. That at 11 o'clock, she recorded him in that last recording. She went to bed. It was noon the next day when the husband shows up and tells her to call 911.
Yeah.
That's 12 hours. That man was in a suitcase. That's brutal. Oh, that is just, I mean, imagine that he survived in there. And just picture this. Imagine that he survived in there for 10 hours.
Mm-hmm.
And those last 2 hours, he's just struggling. I mean, that really puts into perspective how much disregard she had for this situation. She's no different than somebody getting behind the wheel of a car whenever they're shit-faced drunk and killing a family of 5 on a highway. No different. I have just as much sympathy for it as that. This attorney is a crotch rocket. He's, well, he's, what was it that, how does Yamaha put it? His, never mind, I won't say that.
Castle, Chelsea Castle. And they end up, Debbie Castle was pregnant, or Detective Castle was pregnant. So they end up, hey, we're not going to bring your phone, I'm not feeling good. Pregnant, can you come to the sheriff's department, please?
And he's going to say this, but that's not true. That's not at all what happened. The detective, she testified to this in the pretrial testimony. She was just like, that's not at all what happened. Says we asked her if she wanted to come down and she came down, and that's just protocol. They come down for their equipment, and we wanted to ask her some more questions. She came in willingly, and it is just absolute garbage what he's saying. But he also knows that she's not going to be testifying. I want to know how attorneys can defend people like her, because it's their job. CJ, that is absolutely their job to defend their client vigorously and effectively. And that's what and as shitty as I think he is as an attorney, he's doing exactly what he's supposed to do.
Yep.
I'm not faulting him for that at all. I'm just saying he's a shitty attorney.
Yeah.
But he is representing her effectively. Absolutely. It's amazing that he did take it in the first place. And all I'm saying is he's doing a crappy job at it, and he's got a lot. He doesn't have a lot to work with here, because it's somebody that is clearly guilty by their own admission. And if he's doing this, kudos to him. I'll just say that he's He's a, yeah, he doesn't have a lot to work with, but he's doing his best with what he has.
Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videos. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, you got to come up here. We need to talk to you.
He might even know
And
that.
we got her in the room. It's a small room.
Yeah.
It's being videotaped
Still
and
above,
audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she
That
lied.
was later.
She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand.
Yeah, but only if you're under attack. That's the only time you have a lawful right to defend yourself.
Mm-hmm.
At any point, she could have removed herself from the situation. And you don't have to be an attorney to understand the nuances of that. This is like her this is number 9, her number 9 attorney.
Wow.
Yeah, attorney number 9.
Understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you.
Absolutely.
And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about the law evidence, other evidence that's consistent with the testimony that Sarah Boone did. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it, injury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint for a blocking of an attack. But it was unconventional.
No. You can't effing advise her. Absolutely not. No, here's the thing. Self-defense, you have to have a threat of imminent danger. And then any means possible. And she had the means and the opportunity to remove herself from the situation. And she didn't. She took her ass to bed and left him locked up in a suitcase. That's not, you can't claim self-defense over that. You can try, but it's not going to end well for her if she tries to. I mean, but it's all he's got. It's the only thing that he's got in his handbag of bullshit.
Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involve the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe, at least in there. So her attitude is not one of distress. We're here today, full, packed courtroom. Judge Crane's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why
Well, he's correct, but he's incorrect, because if you're claiming self-defense, you have to prove self-defense. That's the problem with it. You can't presume somebody is innocent if you're claiming self-defense. Okay, so he's correct. You have to presume someone innocent until they're proven guilty. But as soon as you make a claim of self-defense, that turns you into the aggressor. And now you have to disprove it. That's why she's going to be called to the stand. That's why she's going to go to the stand. That is going to be a shit show. I hope she does testify.
Can't wait.
She has to, because the state will tear her completely apart.
Oh yeah.
There's no doubt in my mind, because all they have to say is, at what point did you think about letting him out? How did you think this was going to end? You're claiming self-defense. So at that point, you have to prove self-defense.
Yeah, she's claiming hide and seek too. And that's not, come on.
And being drunk is not a defense. Ask any DUI attorney, they'll tell you the same thing. Yeah, being drunk is not an excuse for deleting a whole bunch of people.
Yeah, she's not justified no matter how you look at it.
No.
Well, the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt.
Right.
You are going to have doubts about this case. But the most important thing is not rush the judgment, to keep an open mind and understand there's two sides to this case.
There's only one side. There's the truth,
so
and then there's Sarah's side.
Somebody ended up dying.
That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony.
Thanks, Zach. Appreciate you,
It's
brother.
been mentioned in experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences.
No, I would say alcohol. Alcohol is what affected her ability to think for herself. But as Zach says, on and on, she just keeps lying. See, everyone says Samsonite. It's actually American Tourister.
Experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not.
Yeah, being drunk
After
won't
hearing both
get you out
sides of
of
this
this.
case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty. Because it's the right thing to do.
No.
Thank you, sir.
No, that's not why you find someone innocent, because it's the right thing to do. You find someone innocent because they're innocent.
Yeah.
Ah, jeez. Zach, killing it.
Can the parties approach for a moment? State, you may call your first witness.
State will call Juan Torres.
Now, I'm giving you guys a heads up. I removed all of the exhibits out of this that I possibly could, just to shorten it down in the amount of time that it would take to go through it. If you haven't seen those, I do have those uploaded, which is including the suitcase videos. I've covered these before. If you're really interested in digging in on it, I wanted to get what the state's case was, and what the cross questions were going to be. I found that taking that extra hour out of it really helped out quite a bit, because that extra hour is just mind numbing. It is insanely mind numbing. Let me see if I did this. I don't think I did. Because I'm an idiot. Thought I did. Paste. If you want, there we go. Totally forgot about that. it was MG that I told him I would send him an invite if I was streaming this. So if MG jumps in, there's a possibility he might. On and 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 on. Yeah. So you won't see a lot of the evidence that comes in. A lot of it is really just like photographs, a couple of the videos, which has their interview with the police, and I just cut those things out. I was like, I know that they're important for the case, but you can catch those at another time. I just wanted to, because I did not. And I also tonight, you'll probably see it in probably about a half an hour. Both those videos are going to drop where I've got the full one with all the evidence in there. And then I have this same one right here that's been edited down to cut down on time. So you can always check those out if you need to. I've been trying to find the name of those birds in my intro video. Those are baby peacocks.
Aww.
Yeah, that's what those are. Baby peacocks. So I thought people knew that's what they were. Yeah, those are my little birds. We'll be on with Megan in 30 minutes. Oh, excellent. Yeah, I think they're probably going to be doing some video gaming streams. Those are pretty cool. Is the first witness. This is George's brother.
Sir, good morning. You can be seated. And once seated, if you would state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Castleberry.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or something.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I would say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Pretty close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Oh, yeah, Sarah.
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Right.
Something about choking or how he choked her. I really don't. That pretty much that was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Good fun, Cynthia.
Because she was yelling in the background, so that was it.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Damn.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
You want to ask him a question? Go ahead.
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother, Jorge Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir. Let's go back to this phone call that you were talking about that was on February 23rd of 2020, and that phone call was approximately 7:30. Is that correct?
Yes, sir.
Yeah.
And who called to?
He called me.
And then y'all were talking. Is that correct?
Yes, sir.
And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No. Because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
No, but Sarah had been.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that
Yes,
correct?
it was.
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
No, because she was drunk.
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No?
There you go. That's honest.
Sir, at some point your brother said he had to go, is that correct?
Yes, sir.
And
Why?
did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can.
You may, sir.
Well, sort of. No, the defense has had the same amount of time. The state has had this case for just as long as the defense has had this case. You have to remember that Sarah, her defense, she is responsible for how the case goes. Her inability to work with her defense team, and almost 9, she's on lawyer number 9 now, has been difficult. So this attorney has only had it for 34 days. But yeah, I mean, the thing is the defense has had this case for a very long time. They've deposed witnesses. They've talked with the witnesses. All of that was given to Sarah and her attorney whenever he came into the case. He, at any point in time, she could have taken the plea deal, which would have saved the state and her all of this heartache, for something she's obviously going to lose. And it is unfortunate. And I say that because she is cuckoo for Cocoa Puffs, but I say it is unfortunate that she's going to lose this, and that plea deal would have probably been the sweetest thing that she could have gotten. But again, she's being difficult, and that's typical Sarah, as you'll find out throughout this case, especially when she gets up and starts talking about herself. It's not going to be looking good for her, because a lot of things she can't talk about because they'll be hearsay.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
The family has no love for Sarah.
Thank you, sir. No further questions.
That's all
Any
there.
redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Oh yeah, that plea deal went away. So here's the thing. She was offered a plea deal early on in the situation, in all of this. She turned it down. The plea deal right before the case was supposed to go on, I believe it was the last hearing that they had, where she was still in her prison garb. The judge asked her if she wanted to take a plea deal. The one was on the table. She was being offered a plea deal. She turned it down. And basically the plea deal that she would have gotten would have probably been pretty damn close to time being served with a small amount of time, because they do feel, the state in their original case was just like, she was drunk. We understand that, let's give her a deal. We can't let this pass because this is unacceptable behavior. And we think that, want to give her a pretty decent deal. And she turned it down, thinking that she could win the court of public opinion. And this will be something that I guarantee you, whenever she loses, immediately they'll be filing an appeal.
Oh yeah.
There's no doubt in my mind. Yeah, hopefully the state will be smart enough to trigger her into admitting the true portions the detectives could not get her to tell outright. Her smartness, yeah, she's smarter than everybody. Gotta love those ones.
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Yeah, that was quick going through. Like, he does go through the witnesses really quick. If I'm not mistaken, it'll be that there's just a mandatory that will be in effect. So I think it'll just be automatic. If they find her guilty, the judge may be able to, knock some of her sentence off. I think it'll come down to the judge on this one, but I could be wrong. But this in Florida court, I can't guarantee which one that is. Like because certain states, the way they have it set up is if once they do that, then they have a hearing trial. They'll have witness or impact statements by the family, both on her side and on the prosecution side. I think that the judge will probably most likely, because the amount of time that she's been in jail, would just give that as time served, which doesn't take much off of what is it? I think 30 years that she's looking at right now. So 25 years she would be out. I think this is the neighbor. Could be wrong.
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
Okay,
And
so
at
this
what
is
location?
the
Currently
store
the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in
I used to
February
live on
2020?
Goldenrod.
Yes, I was.
I would say something dirty, but I'm not going to.
Your Honor, may I approach
I
the
knew
witness
that
who's
gets
been
smiled.
previously marked for identification as states D and been shown to defense?
D's and Delta?
D and Delta.
Yes, you may.
This guy worked at Publix.
Sir, I'm showing you he's been marked for identification as states D. Could you use these scissors
it
and
happens.
open this and look at the contents of this package to yourself?
Sure.
Takes a knife, starts like, no, I don't want to be here. He said, open the package. I'm not opening the package. Oh, sorry for the migraine, Tammy. What's in the box?
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly inaccurately appear to be the receipts from your Publix store?
Yep.
Your Honor, this time I'd like to move what's previously been marked for identification as states D
wide
into
part.
evidence.
Any objections? No objection. What was
I don't know
pre-marked as
about
states
that.
D will be received into evidence without objection to states 1.
That is a weird haircut, I guess.
Your Honor, may I approach the witness who's been previously marked for identification as states J and shown to defense?
You may.
22 and a half years. Okay. So she would get 13 years, something like that.
Sir, I'm showing you it's been marked for identification as
Minimum.
stage J. Can you take a look at that disc?
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did.
I
Yes.
was not looking
And
at
tell us,
dicks,
what is that
man.
disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of
Oh, that's
business,
bad.
are the videos from those surveillance cameras kept?
Yes.
I didn't even think about
And
that,
are these
Angel.
the cameras taken from
That's crazy.
February 23rd, 2020? And I believe there's two video clips
My
included.
mind is wasted.
One at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly inaccurately represent the surveillance
All right,
video
thank you.
that was
Where's the
submitted
way?
from Publix to law enforcement in this case?
They do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification, the state's J, into evidence.
Any objections?
No objection.
What was pre-marked as States J will be received into evidence without objection to States 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day.
Beautiful. I love it. Yeah, there was nothing for the defense to say on this.
State, you may call your next witness.
State will call Joan Williams.
Yeah, that receipt was just about the wine. That's why it was so short. It was just like, did Torres buy this? Yes. And the defense isn't disagreeing with it because they're just like, yeah. I mean, here's most cases, and I will, if this prosecutor or the defense would have been here from the get-go, they probably would have just allowed that into evidence without having to have anybody verify it. But because the defense is so late getting to the game on this, her current attorney is so late getting to the game on this. That's why they had to bring it in. They had to have reason to bring it in, and they had to have somebody verify it. A lot of times in a lot of these trials, just to save time, and because the defense isn't going to disagree with it, or the prosecution won't disagree with it, they will just automatically allow certain evidence. They'll have an evidentiary hearing, which basically they'll say, we agree with all of this evidence coming in. So that way they don't have to verify it. They don't have to go through that process. They can say, yes, this is a true and accurate description of X, Y, or Z of whatever it might be. And they'll just allow that stuff in. So that's probably why they went through a lot of these witnesses right from the get-go. It does help shorten things up. And also, kudos to the defense of not making a big deal out of it. Just like, yeah, let's get this show on the road. Let's get done with it, kind of thing. So that's pretty good.
Lizzie, I'm gonna jump off here.
Hey, little D, you have a wonderful one. It was so good to see you. I'm glad you could
No,
stop
it's so
by.
fun hanging out. It like gets my mind off things, and I haven't heard a lot of this stuff, so I'm really glad to catch up with you.
Absolutely.
All right. Well, you have a great night. Good night,
Have
chat.
a great night too.
All right.
Little
See you
D.
later. All right.
Bye.
Bye.
Everybody, give some love to little D. She's awesome. Little Danielle. Mm-mm-mm. Now that's a statement for address. She has more hair than that defense attorney has. I'm going to try to make some stew tomorrow. We finished up the brisket chili last night. Ooh, or tonight we finished that up. That is so good. Oh man. I'm fat and happy right now. Just saying, it was good.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan, Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the County Sheriff's Office.
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical. We try to transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Nice.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness who's been previously.
Oh, thank you for the reminder, Lilu. I've got to pull out a chuck because I'm going to do a Mississippi pot roast. If you guys ever had a Mississippi pot roast, if you've never had one, so perfect, so easy to make, really simple. You have to have I think it's a full stick of butter, and you cut that into smaller pats. Might be a half stick of butter, but a full stick of butter, cut that into smaller pats. You put it on a chuck roast or any kind of roast, and you put those on top of it. Then you put some ranch dressing and au jus on top of that. The ranch dressing is that powdered kind, like Hidden Valley Ranch. Just sprinkle the powder on top of it. Sprinkle the au jus, which is also powdered on top of it, and then take pepperoncinos, which are those little green peppers. You put those on top of that also, and let it cook for regular time. And you end up with like the most tender roast beef, and it's got lots of like tang to it, a lot of spice. Mix that in with some mashed potatoes, or you can do rice. Is what I like to do it with. So that is really good. And then you take whatever char you have left in the bottom, mix a little bit of water in with that, get it nice little stir to it, and then add some. Yeah, Mississippi pot roast is off the hook. And then take a little bit of what do you call it? Flour. Add a little bit of flour to it, and just to thicken it up a little bit. And then you got a gravy to pour over the top of it. So sweet, so good. Yeah, school. Oh, that sucks. That sucks, Tammy. You've never heard of that? Look up Mississippi pot roast, and there's like 5 ingredients. It's absolutely perfect. Throw it in a slow cooker. Sweet, easy meal for like a week. if you're like, it's just me and my wife. Yeah, that feeds us for like a week. So good, so tasty. Roast beef with honey, roasted veg, roast potato, mash, Yorkshire pudding, gravy all over it. Delish. Yeah, I do what I usually. Oh yeah, you should totally try it. It's absolutely the best. Oh yeah. Always looking for new stuff to make. That came from a sister-in-law. I'd never heard of it before. Sister-in-law made it. It's much better than like the pot roast where you throw in all your vegetables and potatoes and cook all that stuff up. I mean, that's fine, but it ends up being more of a stew. But if you cook a Mississippi pot roast and then just make your mashed potatoes separately or your rice separately, it's just like yeah, you can't beat it. Very filling, very healthy. You're out because of the honey. Oh, God, that sucks. Yeah, so I'll probably be making Mississippi pot roast. I have like 4 bags of frozen stew that I made last year from like I might have used brisket for that. I don't remember, but yeah, I've got lots of frozen food. Love them. Well, she just can't do honey. That's all, Lilu. She can't do honey. Yeah, I see. I do most of the cooking. My wife, she made cornbread for the chili. Oh, it's just, yeah, it's off the rails. Good.
Previously marked for identification, the state's L has been shown to defense.
Ma'am.
Ma'am, I'm showing you what's been previously marked for identification as state's L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Yeah, so this is just them bringing in evidence. And if I disappear off camera, it's because I'm pulling out a roast so I can do Mississippi pot roast tomorrow night, because we don't have anything for dinner like here. We have no meat. We've got plenty of vegetables, but no meat. We do have some bok choy. I think I'll pull out some tips also, so that way we can cook those up and maybe do a stir fry tomorrow. So if I disappear off camera, that's what I'm doing. I'm actually pulling meat out of the freezer. It's awesome. Oh God. And tomorrow I'll be doing more of the, I've been grinding. I ground down my front porch, and I've been laying tile, and I got half of it done this morning. or this today. And then tomorrow I'll be finishing that out. And then next weekend I'll be grouting it in. So woohoo, hooray for me. But yeah, that's yeah. So tomorrow would be a good day to do the Mississippi pot roast. Probably sit out by the fire pit with my wife tomorrow night before I do the spicy Sunday stream on Sunday. It'll be good. It's gonna be a good weekend. Apple butter today. You never heard of apple butter? Oh, my wife makes that. It's good.
Thank you, ma'am. Can the parties approach momentarily? Call your next witness.
State will call Vincent Battaglia.
Raise your right hand, be sworn. Please be swear over the testimony you give shall be the truth, all the truth, and nothing but the truth, so help you God.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Good morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Motes? Yes. Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and Jorge Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and Jorge Torres' apartment?
Yeah.
Oh yeah.
How often would you hear this?
Almost daily.
Jeez.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time?
It was pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
Wow.
And do you remember how much before the date when the police called that this occurred?
A few months, probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like, if I do hear anything, like through the walls or whatever, is out back, just kind of keep my mouth shut, like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to record anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
The that sticks out to me from that night was literally just the loud. There was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Did you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. And at the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres' voice?
Yeah. All the time, it was like a back and forth.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was like where my bed was positioned. It was kind of towards the back of the apartment.
I'm with you on that, Lilu.
And it almost sounded like it was coming towards me, but like on the side of me, that it was just like a loud rumbling noise. Like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor like all around, very thin.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
This is going to be good.
Good
morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year?
Yes, sir.
Are you aware that the police were called to their residence?
Like,
while you were there for the year, are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you.
Yeah.
Just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know, from your experience with Sarah Boone and your experience with George Torres, that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Hold on.
Yes, sir, of course.
Man. Did you ever see a donkey punch? No, never saw that.
I think you had testified, you may have given a statement to law enforcement?
Yes, it was one of the detectives.
A recorded statement?
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020?
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object this to improper impeachment.
Approach.
Yeah, this is ridiculous. I didn't realize there was this one in there. I thought I got all of them, but I didn't. Damn
Objection's
it.
overruled for now.
sir, would it be fair to say on that date you got home around 7 p.m.?
7 p.m.?
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon. Because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could right hear clearly. It was like around 10:30 at night.
I would bet the same, Doug.
Thank you.
Would bet the same.
Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes. All right, sir. You are released, not subject to recall. Have a great day. Thank you.
Oh, that was quick.
The state would call Brandon Motes.
Yeah. Yeah, no problem, sir, Frank.
Bless you.
You be good. You be good. You want to see me? You want to see me help with the fence being put up? I've been tiling all day. I'm going to be doing that again tomorrow. I wonder if my wife got some Advil. I'm going to have to bother her and make sure she got some Advil or some pain relief medicine. She was digging holes all day. She's transplanting her blueberry bushes, so I need to go check on her really quick. Damn it, I suck. I'm going to let this guy play. I'll be right back.
Raise your right hand, please, for me. Shall be the jury for the
Thanks, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Motes, BRANDONMOATS.
Thank you. Mr. Castro, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like, the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment. So they had a staircase running right next to the walls, next to, like, our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you could definitely hear it.
And
yeah. Whew. All right. My wife, the lovely wife that I have, she's been digging up blueberry bushes. She said, "Oh, make sure I take some Advil before I go to bed." And then I started talking with you guys, and I was like, "Oh, I should probably take something to like get rid of the pain that I'm going to be feeling tomorrow." And thank you, chat. Thank you very much, because I went up there and I asked her and she's like, no, I hadn't taken anything yet. She's going to be feeling it tomorrow. She's going to be feeling it tomorrow.
How often
Thank you.
would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably. Like, earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that have been, on the first floor or the second floor?
We had a first floor apartment.
Okay. So all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and then it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Oh.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally, like, it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
No further questions.
Any cross-examination?
Yeah, good luck on trying to save this one.
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or Jorge Torres. Is that correct?
Yes, sir.
I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Okay. Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
So I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay. Thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
And you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
Now I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was like 10 something, Initially, it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5 because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after I took, because I came home, I made myself lunch and I took a shower, and then I heard all of their arguing, so it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
Honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth.
Well, let me ask you this. Did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
Okay.
Well, he is in the South. Yes, he is very clear with his
If I can
answers.
confirm, Judge. Yes, sir, of course.
By the way, I just pulled this up. This is awesome. Georgia's beating Texas 23-8. Go Dogs. Tennessee won tonight too. So sweet. I was just pulling that up. I was like, 23-8. Third quarter, 3 minutes left. Oh yeah. So anybody that's watching football, there you go. I beat you to it. Hooray.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right, sir, you're released subject to recall. Thank you. Can the parties approach? Members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. All right, we're back on the record. State of Florida versus Sarah Boone, 2020 CF 2603. Can I get appearances for counsel for the record, starting with counsel for the state?
Dave Kester on behalf of the state.
Yeah, he was
William
good.
J. for the state.
Defense.
James Owens for Sarah Boone.
Kelly Henderson.
He's probably never been in court before.
Ms. Boone is seated at counsel's table wearing the same black suit and pink blouse from this morning. State, anything we need to address before we bring back in our panel?
Can we get the evidence projection system up and can we test it before we?
Yes.
All right.
Some persons behind me to my right and my left. I run the mock trial program at Barry University School of Law here in town, and these are some of my students as a member of that program, so they're here just simply to observe. So pay no mind or attention to them. With that, are we ready to bring in our jury?
Yes, Your Honor.
All right, so they're going to bring back in the jury. There is going to be, and this is where I cut out all of the witness testimony, so you don't have to sit through all of that again. If you've seen this before, which I have seen, all of the, pretty much all of the evidence. I will have this coming. Well, actually, it is out. So if you want to see the full version of it, I do have that out. I also have the edited version up there, and this was with the, with the enhanced video. Feel free to check it out. It's there to free. You have free use to use it however you like. The only thing that I ask, just, give credit. That's it. If you want to use it and show it on your channels, feel free. So here we go.
Members of the jury, good afternoon. I hope you enjoyed your lunch. Record reflect all jurors' hands have been raised. With that, the state is going to continue with their evidence presentation this afternoon.
Mr. Goldenrod, your right hand be sworn, please, and you swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Sir, good afternoon. You could be seated. After seated, if you could please state and spell your name for the record for us.
Brian Boone.
Oh, this is the cock husband. Jeez. Looks like he could be your brother. Why did they say what color top she's wearing? I heard this a lot. Well, they say that so they can identify her as being the defendant, so there's no confusion. And it's just to make sure that it's the same person, that somebody just gets swapped out in the process. That's pretty much it.
Brian Boone.
Thank you, sir. You may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you know the defendant?
I dated her for quite a while, and then we eventually got married.
When you say you dated her for quite a while, how long are we talking?
I met her in the late 90s, and I believe it was around
gay in the first time.
2005 when we got married.
Did you have any children as a result of your marriage with the defendant?
Yes, we had one son.
And how old is that son?
He is currently getting ready to turn 14.
Did your marriage with the defendant last?
No, it did not.
And approximately when was it that you separated and began proceedings for divorce?
Probably 2017, I'm thinking maybe.
And at that time, when was your divorce actually finalized?
Maybe it was 2006. I think the divorce was 2017, I believe.
And after you...
I'm sorry, man. I thought the guy was a cuck, but I figured it out. He is gay. Whoa, jeez. Like, I have never heard gay, and they would say, yeah, this guy swings for the same team. Just saying.
Your divorce, what was your custody arrangement with your son that you had in common with the defendant?
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
Hey, Puddletown, good to see you.
Was this still the same custody arrangement in February of 2020?
Yes.
And in February of 2020, do you recall the events that occurred, I guess, first on the late evening of February 23rd, 2020?
On that evening?
Yes.
Well, apparently Sarah called me at one point during the night.
Do you recall about what time she called you?
I think it was 11 something.
When you answered the phone, how did Sarah sound on the phone?
She sounded like she had been drinking, was pretty drunk.
Were you able to understand what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally I kind of just try to ignore it, so I wasn't really paying attention.
Who was she living with at the time?
Jorge Torres?
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning, on February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
Jesus.
And why was it that you were calling her?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was going to try to find out if she was going to be actually picking him up that day.
Apparently
why would
not.
You have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Do you remember at what time on February 24th you actually got in touch with the defendant?
I think it was like 12:30 or something.
And when you actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
What did you advise her to do?
I told her she needed to call 911 and that I would come over as soon as I could.
And this is on your first phone call here at approximately 12:30.
Yes.
On 2/24/20.
Yes.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first one.
Well, I mean, I live a minute or two drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in his crate and stuff like that and put something on because I was working from home. And total time, maybe 10 minutes.
When you arrived at her apartment, tell us what she told you when you arrived.
George was dead, and once again, I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep. But I, at that time, told her again she needed to get 911 called to get somebody over there.
Yeah, call
Has
911.
she called 911 at this point?
No, she had not.
Jesus.
So you've advised her now 3 times to call 911.
Yes.
Did you go inside of her apartment?
I walked in the front door into the little tiled area, like entranceway thing.
What, if anything, did you observe when you made it to that point?
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out.
She was going to have a cigarette and a drink. Good Lord. What the hell, man? It's like, I'm going to grab a cigarette and a drink because, wow, this is just some heavy shit right here, man. Like, wow.
Out front and got in my car and waited for people to show up.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone, but I wasn't there for the whole conversation. No, I was outside.
Smart
Did you stay
man.
there at the scene while police arrived?
Yes, I was there. I was part of it. I knew I'd have to talk to somebody, so
Did you talk with law enforcement?
I did.
Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Cheese
We'll
strips.
reserve our questions for when we call them in our case.
Okay. All right, sir, you're subject to recall.
Okay.
Thank you.
Thank you.
Yeah, you notice they had no questions for him. Yeah. She was told 3 times to call 911. And whenever he got there, she wanted to come outside and have a cigarette and a drink. Wow. Yeah, he should have. Wow.
Just as long as he remains under subpoena.
It's my understanding he's subject to recall.
So somebody will contact me about that?
Yes, sir.
All right, thank you.
Thank you, sir.
Wow.
State, you may call your next witness.
Your Honor, may we approach a moment?
Yes. Members of the jury, we'd appreciate your patience for a few moments while the state attaches a Bluetooth speaker so that they may publish some evidence that's been received so far. Mr. J, whenever you're ready, sir.
Yes.
Okay, ma'am, this is, so this is any colder than this?
Yes.
Okay.
Well, it's not necessarily cold, but it's just.
Right, okay. Okay, now, I want you to live inside this back for me on the door. Remove the pillows, okay?
Yes, okay.
All right, okay, wait.
Yes, and purple.
Right, okay, listen, okay, man, that's fine. We're still looking for the compression slip, okay? All right? If you look your hand on this breastbone, ready to set up your chest, ready to the nipples.
Yes.
Put your hands up on that hand.
Ready, I'm telling you. This is what I have to tell.
Okay,
Sweet, okay, your girdle.
okay, listen to me. All right, I want you to take the heel of your hand. Okay, right between your chest, right between the breastbone. Put your hands up on that hand.
Doug's like, yep, he's a rhinestone cowboy. Yes, a little. Yeah, he's quite a bit effeminate. I mean, hey, you do you. But yeah, but you called it right away. No, the only reason I say that is my my neighbors are gay, and and they one of them acts the same way, has the same speech patterns, I guess. It just sort of like you pick up on those things. You're like, oh, that guy's okay. I'm not so hard on him for being such a cuck, because, well, he was probably, adding an O to that. Just saying.
We want the pump his chest to be hard and fast. 1 minute twice per second. Okay, no, just keep on pumping. That's all you need to do for me. Keep on pumping his chest over there. I don't need you to stop and talk or anything.
I mean, unverified, but hey, that she goes for the ladies too. So I mean, maybe they had some sort of mutual thing where they would, share partners. Fuck if I know. It's creepy. It's creepy. I was trying. Hey, that's a possibility. That's a possibility. I've known people like that where they play that kind of stuff. The bi doesn't exist. Just saying. The guy before him was also I think the guy before him was also, but I think all three of them were. But hey, you do you, or other people, whatever.
Just want you to count out for me, okay?
1, 2, 3.
Law enforcement.
Yeah, I don't have time to listen to the 911 call. This, if I'm not mistaken, is a property manager. Maybe she used too many plugs on him and turned him. I don't know. Greediness. Jeez, she might be driven to him to be gay. I don't know. This is, if I'm not mistaken, is the property, the guy that works the property.
Sir, good afternoon. Could you state and spell your name for the record for us?
Yeah, this is the guy that worked there at the apartment complex.
Mr. Castro, you may inquire.
Good afternoon, sir.
Good afternoon.
Tell us, what do you do for a living?
I'm a maintenance supervisor for apartment complexes.
Is that what your position was back in February of 2020?
Yes, it was.
And what apartment complex?
Tealwood Park Apartments.
And how long did you work for Tealwood Park Apartments?
About 2 years.
And tell us, what were some of your duties in your position there with Tealwood Park?
Daily, I cleaned the grounds, walked the property, answered maintenance calls, did emergencies, dealt with vendors.
Did you become familiar with the residents there at the apartment complex?
Yes.
Did you have occasion to meet the defendant in this case and also a Jorge Torres?
Yes.
Let me turn your attention to February 24th of 2020. Do you recall that date?
Yes.
And on that date, did you have occasion to come in contact with the defendant in this case?
Yes.
Frank, that's funny.
And tell us, what was the circumstances in which you came into contact with her on February 24th, 2020?
I was called by the manager and the assistant manager to come to her unit. I believe she was already sitting outside at that time.
Well, that's funny, Frank. My sister turned her boyfriend gay from high school. Turned her boyfriend from high school gay, or it was the Navy. The world may never know. Or maybe he was already like that in the first place. You never know. It's so obvious none of these people like Sarah Boone at all. Well, you also have to understand that this is the prosecution's witnesses. So it's very likely that they don't like her a whole lot. Just saying. Oh my God. Yeah, that's got to be hard on a woman though. Just imagine she's dating some guy and then it's just like he comes out and says, "Oh, I'm gay." Imagine how the woman feels in that situation. Be like, really? Was it because it was that bad? It was that horrible? You never know. Could be.
And when she was sitting outside of her unit, what, if anything, did you observe about her and about the unit?
The police was there. Her ex-husband was present. She was sitting outside, and that's when she decided she wanted to talk to me and the managers.
And what did she tell you?
She's confused. She's not exactly sure what happened. She pointed out that she recalls that they were playing a game of hide and seek. There was an instance where she was going to teach him a lesson, and then she just doesn't recall anything else until the next morning.
Did she say she fell asleep?
Yes, she did.
Did she say things got out of hand?
I don't really recall that part, but I do recall her stating that they were playing their game and that George went into a suitcase, and I didn't ask any questions. I just let her talk for herself
How long was this conversation?
for about 4 or 5 minutes.
Your Honor, I have no further questions at this time.
Any cross-examination?
Master of arms.
You may inquire, sir.
Wow.
Good afternoon, sir.
Good afternoon.
This conversation that you had with Miss Boone,
Yes.
that took place on the 24th? Is that correct?
Yes.
And who else was present on the time that the conversation was taking place?
Standing right next to me would have been Melissa Sexton and Eugene Harris, as well as the officer who was in front of the door.
Okay. So there was a law enforcement officer there that day, is that correct?
Yes.
All right. Now, on the 24th is when you said that Miss Boone made this statement to you. Is that correct?
Yes.
They were playing hide and seek?
Yes.
And what else did she say happened?
She had told me they were playing hide and seek. They had drank. She was trying to teach him a lesson, and that was that. She went upstairs. She went to sleep. She woke up. She doesn't know what happened.
Okay. So that was on the 24th.
Wow.
All right. On the 26th, were you not interviewed by law enforcement?
Yes.
Okay.
I may have my days wrong, but it all happened on the same day.
All right. The 24th, do you remember 2 days later that a Detective Scott Lowen conducted an interview with you at 4704 Lucier Court, Winter Park, Florida? You remember that interview?
Yes.
So that was 2 days later, is that correct?
I would assume so.
Yes. All right. So when he interviewed you 2 days later, did you tell him about this statement that Miss Boone made to you that you just told this jury in court?
I did mention it to him.
You did mention it to him?
I mentioned to them that we did have a conversation.
Did you tell him the content of the conversation?
I may not have told him the whole content, but I did tell him we had a conversation.
All right. Well, what did you tell him? What content did you tell him on the 26th?
That they were playing hide and seek, that she was confused, she doesn't know what happened. I do believe I did mention to him the fact that she had said that she was trying to teach him a lesson. Not that anything was done with malice. I didn't state that at all.
Okay. So it's your recollection now today that on the 26th, you told Officer Lowen what you just told this jury. Is that correct?
Yeah.
All right. Sir. In preparing for this case, did you have a meeting with the Assistant State Attorney on September 23rd of 2024?
Did I have a meeting?
Yes.
A brief chit chat over the phone.
A brief chit chat that was over the phone?
Yes, sir.
All right. At that point in time over the phone, did you tell him that Sarah Boone, the defendant, stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
Yes.
Is that what you told him?
Yes.
Okay. And that was in 2024 of September the 23rd of this year, 2024. Yes. Is that correct?
Yes.
Are you telling us that back on February the 26th of 2020, you told Officer Lowen at that time the same thing?
No, as I recall, yes.
Don't try to do the I gotcha kind of thing. It's not going to work for you.
So did she ever tell you how things got out of hand?
No.
Sir, you testified that you knew both Mr. Torres and Miss Boone, is that correct?
Yes.
You actually knew George Torres from a different time, didn't you?
Yes, I did.
When did you first know George Torres?
In the 1990s.
In the 1990s?
He was a teenager and he lived down the street from me and my wife.
So you had a previous relationship with Mr. Torres?
No, not at all.
Not at all? You just knew him from then?
Yes, as I stated, he was a teenager and I was an adult.
During this time, though, that you became reacquainted with him, did y'all establish a friendship at that time here in Orlando?
I wouldn't say a friendship, but an acquaintance, yes.
Okay.
Oh, it's fun.
Sir, on Monday, February the 24th, that would have been the day that you
Yeah,
were with
it
Ms.
happens.
Sexton, and
You know, and it does happen. You know, as much as people like to think that this is a small world, it really isn't. Think about this. There was a guy in my basic training that went AWOL. he got brought back like 2 days before graduation, and they gave him I think it was a dishonorable discharge, and it was about 5 years later. And we did our basic in Fort Jackson, South Carolina, and I went back to New Mexico. A lot of stuff happened in between then, and then I went on tour with this band, and we were playing at Summers on the Beach in Fort Lauderdale, and they were filming a movie. Trying to think what the name of the movie was. It was one of those like B flick action movies. It was really cheesy. There was a football player in it or something like that, like ex-football player, blonde guy. I don't remember his name. And one of the lighting engineers was that guy. I ran into him, and I could remember his last name. I can't remember it now because that was like 30 years ago. But I ran into him, and I just looked at him, and I said his name, and he looked at me and was just like, oh hell no. And yeah, we talked and drank some beers and talked about, you know, the time that we spent in the military. And it was crazy, you know, that how small of a world it is that we took different paths in life and ended up running into each other at some random like movie shoot. It's pretty cool. It's pretty cool. But that's how life happens.
Gene Harris.
Yes.
Out in front of the apartment.
Correct.
Did you talk to law enforcement that day?
No.
You did not talk to him that day?
I don't recall talking to him that day, no.
Okay. Thank you, sir. I don't have any. If I can confer.
You can, sir.
Thank you, sir. I don't have any further questions.
Any redirect examination?
Just brief.
All right, thank you.
Back in the 90s, when you had previously known Jorge Torres, in this case, where were you living at that time?
I lived across the street. I lived on one block. He lived the next block over down in the middle.
In what city?
Philadelphia, Pennsylvania.
And when did you move from Philadelphia, Pennsylvania?
2018, I believe.
So in the intervening years, from your move from Philadelphia to coming to work at Tealwood Park, did you have any contact with Jorge Torres?
No, as a matter of fact, I moved from that particular block in 2005, so I don't meet Judge again until I work at Tealwoods.
When did you start working at Tealwoods?
2018, 2019. Roughly there.
No further questions.
Can this witness be released?
No, Your Honor, just subject to recall.
All right, sir. You'll be released subject to recall. Thank you.
Thank you.
It's all a simulation.
State, call your next witness.
State will call Deputy Kayla Rodriguez.
Oh yeah. Now this is where it's going to cut out quite a bit. So just to share with you guys, the score is now 30-15. Both UGA and Texas have scored 7 points since the last time we said anything. All right, back to the stream. Haha.
Raise your right hand and sworn to swear or affirm the testimony you give shall be
We're in the
the truth,
fourth quarter with 11 and a half minutes
Good
to
afternoon,
go.
ma'am. You could be seated. Please state your name and spell it for the record if you could for us.
Kayla Rodriguez. Kayla, Kayla, Rodriguez, Rodriguez.
Thank you.
Oh, she's a cutie.
Good afternoon, ma'am.
Hi.
Can you tell us did you work for?
Orange County Sheriff's Office,
And what is your position with the Orange County Sheriff's Office?
deputy sheriff.
And how long have you been a deputy sheriff?
A little over 8 years since
Yeah,
2016.
that's what I was saying.
And
Papa
tell
Tom,
us,
she's
what are your
cutie.
duties as a deputy sheriff?
As a deputy, I respond to calls for service, anything from a over with call, like a car being keyed the day prior, or a 911 emergency.
And what type of training do you need to be a deputy sheriff?
So for me, I obtained my bachelor's degree from UCF in criminal justice in 2014. After that, in 2016, I was hired by the sheriff's office. Right after being hired, I went straight into the academy. The academy is 5 months of training. We go over everything from case law, scenarios, defensive tactics, physical training. After that, I do 2 more months with the sheriff's office where we go specifically into policy related to Orange County specifically. After that, I do 3 months on the road with a trainer where we are evaluated periodically through that process. You have a partner, you respond to calls for service during that time, and you slowly learn how to handle calls by yourself.
Do you also tell us what area of the county were you working in?
Orange County, unincorporated Orange County.
And did you receive a call in regards to this case?
Yes.
And what was that call? What information did you have at the time you received the call?
So the dispatcher informed me that a woman called 911. She was actively performing CPR and that her boyfriend was in a suitcase.
And did you respond out to the scene?
Yes.
Like, what
and
the?
when you responded out to the
Okay.
scene, were you dressed similarly as you are dressed today?
Yes.
And just for the record, you
Nice
have
looking Ossifer,
it looks like
yeah.
a standard green uniform on with a tool belt, your firearm, and also radio, body
So
worn
she's
camera.
legal.
badge.
She's at least 18.
Tell us about your body worn camera.
So my body camera is used to capture scenes when we arrive. So as we are conducting any sort of law enforcement action, we turn our camera on.
I'm just saying. I mean, I would videotape her all day long.
When you turn your camera on, tell us, does it immediately capture sound?
I can imagine that.
It does not. When we
exact
activate our
face.
camera, it
Be
goes
like,
back a minute, and the minute that it
okay.
goes back to, you don't hear any audio for that first minute.
Tell us also about the capacity and the battery life of your camera as well.
So the battery will last us an entire shift typically if it's in a buffering mode. So if we're not recording, it will last the entire shift. As we record, it does drain the battery. So typically we will turn it off if we're sitting in our car for an extended period of time. If we call our supervisor, if we're talking to another deputy on the side away from a scene, we will not have the camera recording. If it recorded throughout the entire shift, the battery would die. We would need multiple batteries.
So you actually activate the camera in order to begin recording.
Correct.
It's just my.
Was your body camera operational on this call out?
Yes.
Yes, Nubian Queen.
Your Honor, may I approach the witness, which has been previously marked for identification as states H, I, and G that have been shown?
Okay, so if you notice there's a big skip in there, is because it would have been the body cam footage that they showed. I edited that out of this version of it, just because for time. I didn't want to have, like I said, that stuff is available, and I do have that one uploaded. So if you're wanting to watch the whole portion of all of the evidence that was submitted. And then there was like a whole bunch of pictures that were submitted. None of them were disagreed on. They let all of that stuff in. And it really does bring to light her testimony that she's disagreeing with now.
To defense?
You may.
Ma'am, I'm first showing you what's been marked for identification as states I. Do you recognize that disc?
Yes.
Did you have an opportunity to review that disc prior to coming to court today?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Correct.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of your body worn camera?
Yes.
Your Honor, at this time I'd like to move what's previously been marked for identification as states I into evidence.
Any objections?
No objection.
What was pre-marked as I will be received into evidence without objection as states 4.
Ma'am, next I'm showing you what's been marked for identification as states H. Can you take a look at that disc? Tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Yes.
And did you have an opportunity to review that disc prior to coming to court today?
Yes.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of that portion of your body-worn camera from that day?
Yes.
Your Honor, at this time, I'd like to move with remark for identification as states H into evidence.
No objection to any of those coming in.
What was pre-marked as states H will be received without objection as states 5.
And lastly, ma'am, I'll show you some mark for identification as states G. You recognize this disc?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24th, 2020?
Yes.
And you had an opportunity to review this camera prior to coming to court?
Yes.
And that's your initials on the disc?
Yes.
And it fairly and accurately represents your conduct on the body-worn camera?
Yes.
Your Honor, at this time, I'd like to move with remark for identification of states G into evidence.
No objection.
Thank you. What was pre-marked as states G will be received without objection as state 6.
May we dim the light and use the overhead projector?
Yes.
And this is the evidence.
Ryan Boone,
Yes.
did you take a statement from him as well?
I did.
Were all your interactions with the defendant on that day captured on your body-worn camera?
Yes.
I have no additional questions at this time.
Thank you. Any cross-examination?
No questions, Judge.
Is this witness released?
Yes, Your Honor.
Fine. You're released, not subject to recall, ma'am. Thank you.
Thank you.
Can the parties approach for a moment?
Yes.
Members of the jury, again, if you could please raise your hand, showing that you complied with the court's instructions during our last break. All right, the record reflect all jurors have raised their hands. State, you may call your next witness.
State will call Deputy John Martinez.
Well, well, exactly. But I like I said, I have all of those videos already uploaded. You're welcome to view them at any point in time. I just wanted to get through and see what the prosecution's case was going to be, and just cover it really quick, because there's a lot of stuff in here, a lot of stuff, and you'll see me skipping even through this stuff. It's just because I want to get to a lot of the questions that they're asking. Other than that, it's just sort of regular courtroom kind of stuff. Like, here's the evidence. 5 minutes later, okay, now you signed it in. Hooray. Yeah. Oh, no. I'm with you.
Mr. Martinez, where you are, please be sure to report that this is a child
Sir, good afternoon. Can you state and spell your name for the record for us?
Deputy John Martinez, Johnmartinez.
Thanks, sir. You may be seated. Thank you.
He's got a shiny head too. My head is shiny also. Could be the oil or something. I don't know. The sweat on my brow.
Good afternoon, sir.
Good afternoon.
Tell us, who is it that you work for?
Orange County Sheriff's Office,
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
Oh, nice.
How long have you been with the Orange County Sheriff's Office?
I'm going on my 16th year.
Prior to working for the Orange County Sheriff's Office, do you have any previous law enforcement experience?
I do.
And where was that?
I first started my career with the New York City Police Department.
In New York City Police Sheriff's Office.
My
How is it that what was this location? In Orange County, Florida?
It is.
And when you responded to that location, who did you first come into contact with?
I came in contact with Ms. Sarah Boone.
Do you see Sarah Boone here in court today?
I do.
Frank's
Did you point to her and identify an article of clothing she's wearing?
The lady sitting in the middle with the black blazer.
Your Honor, may the record reflect that the witnesses identified the defendant?
Record will still reflect.
During the time that you were on the scene, did you have a body-worn camera?
I did.
That's awesome. That's awesome, Tammy. You glisten. It's not a blinding shine. You glisten. Have you ever heard of Arthur Knight case? No, I have not. Here's the thing. Whenever I cover a trial, it's because it's something that interests me. I find it very interesting. There's something about it that really like fires off in my brain. And this Sarah Boone like is one of those where I was like, holy crap, this one is, it's not about the covering a trial to cover a trial. It was just like this one here really set something off, in the back of my head that was just, it was important, I felt, to really cover this particular one. You've been hopping Iron Rabbit in and out. Oh, I love Iron Rabbit. She's an absolute sweetheart. No, so you have to remember that you're not pro either, Puddletown, but it's more of they like your style. Damn. See, I need to learn how to get like good thumbnails. Oh, I'm so bad at those. I just need to get better at it. Once I figure out the like system to get these things down, I'll make much better ones. But I'm so horrible at them.
And was that body-worn camera activated?
It was.
Were all your contacts with Ms. Boone recorded on that body-worn camera?
It was.
Were other deputies also on the scene at that time?
Yes.
And was Deputy Rodriguez there?
She was.
So would both of your body-worn cameras both capture some of the same time frames?
Correct, yes.
Did you have an occasion to go inside of the apartment?
I did.
And inside of the apartment, what observations did you make?
When I first entered the apartment, I noticed a Hispanic male laying on his back in looks like a small nook dining area. Later identified Mr. Jorge Torres.
Exactly. This is a very interesting case.
Your Honor, may I approach the witness who's been previously marked for identification as states K and been shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as states K. Do you recognize that disc?
I do.
And tell us, what is that disc?
Is a copy of my body-worn camera.
And does this body-worn camera fairly and accurately depict the portion of the events that took place on February 24th, 2020?
It does.
And are those your initials on the disc?
Yes, they are.
Your Honor, at this time I'd like to move what's previously been marked for identification as states K into evidence.
Any objections? No objection. What was pre-marked as states K will be received into evidence without objection as state 7.
And this one was the most tedious one to go through. Oh my God. Because it's just like, what is this a picture of? What's 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 this a picture of? Oh my God.
Shall be the truth, the whole truth, and the truth, so help you God. Yes.
Ma'am, good afternoon. Can you state and spell your name for the record for us?
Find out to on that day.
I responded to 4748 France Court, apartment 3.
And is that in Orange County, Florida?
Yes, it is.
And when you responded to that scene, whom did you make contact with?
I made contact with the homicide detective,
find out.
Jesse Ketzel.
Did you receive information from the detective?
Absolutely.
Yes, that it was a
Angel.
death investigation.
Absolutely.
Did you walk the scene with the detective?
Yes.
And tell us, what does it mean to walk the scene with a detective in a homicide?
We go into the scene and just observe. We don't interact with anything and discuss what we see. Yes, I did.
Identify potential items of evidence to be collected.
Yes.
You had mentioned previously about
When you were
documenting
young?
scenes with photographs.
Never.
Was that done in this case?
Yes, it was.
You may.
All right, he's going to show her all the
The
pictures.
contents is contained within State's Act.
Yes.
just a closer image to the.
So yeah, this is all the photographs. A whole bunch of them.
When you enter the residence, what is the first area just off to the right of the front door?
That would be the kitchen.
Showing you it's been marked as states 11.
Yes. So. This,
I did cut quite a bit out, even though, and there's probably some questions there you can't prove it, but I think more men get subjected to domestic violence than women, my opinion, but I don't have the data to back that up. Well, there is data on that, Frank. It is more common for men to be involved in well, that's not true, but men are more likely to be involved in domestic violence these days than they used to be. Women are still most likely to be involved in domestic violence, and it's even higher in the gay community. Lesbians can be very mean to each other, and just saying that it does happen quite often with women, and that's where they get a lot of the statistics from. Men are most likely to be murdered, if I'm not mistaken, is higher than the rate of women being murdered, and that's just, yeah, men just don't come forward as often, probably out of embarrassment and shame, because who wants to think that they just got their ass kicked by a woman? That's just like, how humiliating can that be? But you also have to remember that a lot of men don't fight back against their aggressive counterpart. They won't fight back against women because we've been told men are stronger, which not a lie. And if a woman attacks a man, he tends to think of it more of, well, I can knock her out with one punch, or I can take the aggressive nature, but then there's going to be the makeup sex afterwards, which is going to be awesome. But yeah, I don't think that that's any excuse for doing that, though. Here's the bat that Jorge Torres got hit with. Just imagine having to pull this thing out. Yes, exactly. It's like a
What is
Christmas
contained within
gift.
safe B?
the wooden baseball bat.
And is that bat in the same or substantially the same condition as it was at the time that you collected it on February 24, 2020?
Yes, it is.
Your Honor, at this time I'd like to move what's previously been marked for identification as states B into evidence.
Any objection?
No objection.
What was pre-marked as B will be received into evidence as states 10 without objection.
Wow.
Your Honor, request permission to publish.
You may.
Well, and that's true, Puddletown. Most 9 times out of 10, a lot of men will be. But you also have to remember there's those guys that just don't get enough ass that they are like, man, this might be the last piece of tail that I ever get. Which in some cases it ends up being the last piece of tail they ever get because they, use a baseball bat like this on them. Imagine getting hit with that a few times. Ouch.
You also had an occasion to collect a suitcase as well in this case.
Yes, I did.
Prior Prior to placing the suitcase into evidence, did you process it?
I took measurements of the suitcase.
What are the measurements of the suitcase?
It was 28 inches in length, 20 inches wide, and 8 7/8 inches deep.
Your Honor,
Holy
at this time, may the
crap.
witness step down from
Holy crap. 28. Oh my God. 20 in. Okay. So it's 28 inches long. Holy crap. That's tiny. Like the largest suitcase that I ever use. It is, damn, 28 inches, and it's only 8 inches deep. So you're talking about something that's that narrow. That's narrow. 28 inch. I've been laying tile all day. Okay, I've been laying tile all day, and those tiles are 12 by 24. 28 inches. That's just 4 more inches higher than that tile that I've been laying. Holy crap. 28 by 20 by 8. That is freaking tiny. Good Lord. Yeah, no, not even 3 feet. Jeez Louise. Well, whenever they bring out the suitcase, it looks bigger than it actually is. She's lied about that? Oh. Now the size of the suitcase is mind-boggling. How on earth did he get in there? He must be a very small person. Yes. But they bring out this suitcase and it makes me think everybody in this damn case must be really tiny.
Deep.
I mean, here's the thing. Think about this. Your kitchen counter is about 27 inches tall. Your kitchen counter is, I think that's right, 27 inches tall. So put that in your mind. Your kitchen counter is about 27 inches tall. Your drawers are usually about 4 inches deep, unless you've got really deep drawers, and those might be 8 to 10 inches. See, size doesn't matter. No, he was, yeah, still. Good Lord.
Your Honor, this time may the witness step down
Just imagine that box over there. That's where George is sitting.
from the stand and approach the clerk's area.
Yes.
Good God. Just imagine there's a full-grown man inside that box right there. I can't even get my torso inside that box. Of course, I'm a fat ass, but that's different. All right. Look at this suitcase whenever it comes out and think about the desk that the lady is sitting behind. So the width of the desk is, just look at here, I'll draw it out for you. That suitcase, and you can compare this on your own, that suitcase is about the size of this right here, the end of her desk. And the depth of it is probably like that. Something like that. So that's about the depth of the suitcase. And just imagine his head being here, his body all curled up like this. And that's where he was stuffed in there for hours. Just picture that, the side of her desk. No, was there? Oh my God.
Ma'am, I'm showing you what's been marked for identification as States A.
Oh, bet Sarah Boone's just creaming her jeans right now.
What is this item?
This is the suitcase I collected from the living room.
And how is it that you know that this is a suitcase you collected from the living room?
You could have gotten that in your 20s. Jesus Christ, man. In my 20s, I was climbing inside of 28-inch pipes, okay? Just to do like cement repair. Because if you angle just like this, you can crawl in that way. But yeah, getting out's a real son of a bitch. They used to tie a rope to my feet so they could pull me back out. It's no fun. Yeah. That's whenever I had a much smaller waist. I don't think I could do that now. Good Lord Almighty. It's insane.
It has the Orange County Sheriff's Office evidence label that I labeled with the item description. It also contains my name and the agency case number, and my initials are also on the evidence tape.
Yeah.
Ma'am, at this time, could you open States A and look at the contents of it to yourself?
Yes.
Damn. She's around like sympathy.
What is inside of States A?
This is the suitcase I collected from the living room.
And does it appear to be in the same or substantially the same condition
No, not quite. There was a body in it last time I saw it. Oh, jeez.
as the time that you collected it and placed it into evidence?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as States A.
Sweetheart, it's been 4 years. She's over it by now. She's just like, I mean, come on. Come on. Get with it, Lilu. Why would she ever be bothered? She wasn't bothered by it then. Why should she be bothered by it now?
Into evidence?
Any objections?
No objection.
What was pre-marked as A?
The worst part is she's sitting there smiling and grinning. And unfortunately, she doesn't realize that the jury is just going to be looking at her like, really? This chick stuffed a dude into this suitcase, beat the snot out of him with a baseball bat. Do you not think that the jury is going to be like, what the F? And she has no empathy, no feelings about it whatsoever. She doesn't even feel bad about it. Ah.
It will be received into evidence without objection as States 11.
And Your Honor, at this time, I ask for permission to publish States A to the jury.
You may.
Yeah, my suitcase isn't even that big. I'm just saying, my suitcase is smaller than that. Like everything that I have everything that I would need to survive for like 7 days, it can fit into a suitcase smaller than that. That's a big suitcase. Just saying, but they're very short.
Can you open the inside of it?
Okay, my wife has a suitcase that might be that big. Hey, how's it going, Amanda? Good to see you. So just imagine, I was thinking, okay, so he would have had to been laying on the other side of it. All right, so I'm looking at the suitcase. That means for him to have been able to unzip this, his head would have had to been here. His body would have been curled up underneath here somewhere. So just imagine, head's here, and he's curled up inside here. And then he would have had to reach an arm up, grab that zipper, and unzip it all the way around just to get air. Good Lord. Phew. So how did she think he was going to get out of this thing again? Hey, do you know if any YouTubers are attending the hearings? I would love to know what the jurors' faces are showing. If anything, I have no idea if anybody's there at this courthouse. You know, that's time. Lord.
How easy is it to operate the zipper that closes the suitcase?
It was a little difficult.
I have no additional questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor. Good afternoon.
That'd
Good
be
afternoon.
interesting. That'd be cool.
Are you also referred to as a medical examiner investigator as opposed to just crime scene investigator?
No, that is not my title.
Do you do reports that the crime or that the medical examiner necessarily relies upon in the process of doing the autopsy and additional investigations?
You would have to ask them.
Who makes the decision at the scene as to what items will be photographed and what items will be taken into custody, what items will necessarily be tested or analyzed?
That's a collaborative effort between the crime scene investigator and the lead detective while on scene.
That would be yourself, and who was the lead detective?
The lead detective was Chelsea Capsule.
Now, you authored a report in this matter, did you not?
Yes.
And that report was utilized, if you in fact know, by the medical examiner in developing her autopsy report, was it not?
I do not know.
In your report, did you advise the medical, or whomever might read your report, that in fact the body had been removed from the suitcase by first offenders or first responders?
No, I don't believe so.
And we know that you have capacity to do DNA analysis, correct?
No, we process DNA or collect swabs for DNA, and then that's submitted to the Florida Department of Law Enforcement for conventional DNA analysis.
You did that with a sample from the inside of Sarah Boone's mouth.
Her buccal swabs were submitted to the FDLE.
And who made that decision?
The detective and I.
Who made the decision not to bother to do a DNA analysis on the blood from the items within the suitcase or the suitcase itself?
That was a discussion between the detective and I.
And you chose not to do that?
No, we did not.
You assumed the blood inside the suitcase belonged to Jorge Torres, correct?
There was blood observed in the suitcase.
But you don't know who that belonged to because you didn't bother to analyze it or have it analyzed, correct?
The blood was not tested.
Now, State's Exhibit B at the back.
That doesn't matter. Oh, Jesus Christ. Why would you analyze the blood? There's no need to. There's no need to analyze the blood, you dumb.
You took that into evidence. Was that again a collaborative decision by yourself and the lead detective?
Yes.
And what efforts did you make to have the bat analyzed, given the fact that it was apparently evidence?
It was just collected as evidence from the scene.
Did you advise either the lead detective or anybody else involved with this investigation that there may be matters that could be analyzed when analyzing the bat that would help or assist in the investigation of this matter?
It's my job to do the documentation and the collection of evidence.
Well, you said it was a collaborative effort between yourself and the lead detective, so did you participate?
The way this guy is an idiot, the way a collaborative effort would work on this is the detective says, pardon me, the detective would say, hey, I want you to sample this. I want you to test this. I want you to look at this. I want you to examine this. I want you to take a picture of this. I want you to notify this. And then she takes the picture according to what best practices would be. What an idiot. What an idiot question. I see what he's trying to do, but it's not going to work.
In that decision.
We chose to collect the bat and put it into evidence.
And so there was a fiber analysis done on the bat to determine whether or not it was used to strike Jorge Torres when he was in the suitcase. Was there not?
Pardon?
In fact, there was not, was it? There was no effort to analyze the bat.
I'm going to object. I don't believe the witness had an opportunity to answer the question.
Sustained.
I'm sorry. Please.
Can you repeat the question?
If I can remember it, I will. Do you know that there was any effort made in this particular investigation, the investigation of Sarah Boone, to analyze the bat for fibers?
No, there was not.
And why was that not done?
It was not done.
You indicated that you had some interaction with Ms. Boone. Is that correct?
I collected her buccal swabs.
Exactly, Don.
In collecting her buccal swabs, yes.
Did you speak to any other witnesses?
No.
Did you make any determination of other matters that might be of import or evidentiary value when you were
Probably
going through the
not.
house and taking photographs and documenting the interior of the townhouse?
You'll have to be more specific.
Well, how many pictures of the child's bedroom did we see?
Here today,
Yes, ma'am.
we saw the entrance to the bedroom as well as a photograph of the interior of the bedroom.
What was the evidentiary value of that?
It's my job to photograph and document while on scene, so the rooms in the upstairs were photographed and documented.
Did you photograph holes in the wall, possibly made by the victim?
I don't recall photographing holes in the wall, no.
Did you take photographs of items within the house or throughout the house that may have depicted incidents of prior violence?
You'll have to be more specific.
How about bloody pillowcases? Did you make any effort to collect and analyze pillowcases of the rooms that you were photographing?
No.
Who made you have significant experience with zippers?
What? Well, is this guy a complete moron? You're going to waste the court's time on these stupid questions? Like, what purpose? Why would I take a sample of DNA off of a suitcase or off of a pillowcase? Anybody have a clue why I would do that? Did you take carpet samples? Did you take any samples of what kind of coffee they were drinking? Well, how about this? Did you go and do a DNA analysis on their microwave oven? How did you see how much ice they had in their ice cube maker? It's like that. Oh, Jesus Christ. This guy is a fucking moron. Sorry. Oh, he means a suitcase. Well, suitcase is a prison too. Live and die by the zipper. Now he's going to be asking her about the zipper. Are you an expert on zippers? Do you have to be is there an expert on zippers? Can anybody tell me? Is there a qualification of being an expert on zippers, or just realizing that whenever you're trying to unzip something, it's difficult to unzip? How about this? How about we put Sarah Boone in the suitcase? We'll zip it up and see how fast she can get out. Yeah, he's an idiot. His questions are stupid and meaningless. Well, I've got my 5 minutes of, I can bill for this now.
I use zippers regularly, yes.
Enough to have an opinion as to whether or not a zipper is stuck or not.
Is what? Sorry?
You testified on direct that the zipper was a low tight.
Just that it was difficult without the zipper pulls to use the zipper.
And that was your opinion.
Yes, from opening the suitcase here today.
Yeah.
Today. You only
Idiot.
tested it today?
Pardon?
You only today have for the first time tested the ability to pull
What are
open
you
the zipper
talking about?
on the suitcase?
No, I'm saying it was difficult today.
A redirect examination.
That was the stupidest line of questioning.
In this case,
But he billed his hours.
you documented
Piece of shit.
the entirety of the house as you saw it.
Yes.
So every room in the house.
They were all taken overall photographs.
The bat for fiber made sense to me because there wasn't any fibers from the suitcase on the back. It can't be proved that it wasn't used. Oh, okay. Think about this. Because there wasn't any fibers on the from the suitcase on the back, can't be used. Okay. My dog ran into a tree about a month ago, like ran into it full force. There was no fiber from the tree on his head. No fiber from the tree on his head. And there was no fiber from the dog left on there. He's just saying the blood could be Sarah's because George also harmed her. Then say it. Then say it. But it doesn't prove anything. Just proves that there was blood in there. It could have been. He could have been bleeding internally for all we know. I've seen some dumb defense plays. I have a feeling this case just gonna take the cake. Well, the case is yet to been opened.
Walls in the house?
In the overall photographs, yes, they weren't all individually photographed.
Good
no.
day. Exactly.
And you did not document or note any type of holes in the wall or any type of damage to the walls, anything like that?
Not the walls, no.
Is that something that would have been documented both photographically and also within your report?
Yes.
You also, as we've previously seen in the composite, saw the victim where he was laying in this case, correct?
Yes.
Was the victim, did he have blood on his mouth and on his face?
Yes, he did.
Did he have open wounds on his body?
There was blood coming from his nose and his mouth. There was also some other areas of like defects noted on his body.
You also made contact with the defendant too, as well.
Yes.
Did you note any other wounds or cuts or anything else that was not documented that you haven't testified to?
No.
So no wounds, nothing on her?
Not that I recall, no.
No further questions?
Thank you. Can this witness be released?
Yes, Your Honor.
Mr. Owens, can this witness be released?
Oh my
Judge, we'd like her to be on call.
Subject to recall, ma'am. Thank you. Members of the jury, thank you so much for your attention in this matter. It is 4:52. At this time, we're going to go ahead and take our recess for the evening.
And that is the end of it. Good Lord. 4 hours and 11 minutes. I love having it on fast speed. Let's not forget they had a good day. This has been the absolute stupidest line of questioning. Oh my God. 30 seconds left. I got to share this instead. Look at that. 30-15. UGA is beating Texas, #1 team in the SEC, and the Bulldogs, #5, beating Texas. That puts them in the same standings, which would be 6 wins and 1 loss, and Texas is going to have 6 wins and 1 loss at the end of this. Man, oh man, 30 seconds left in the 4th quarter. Oh my, oh my. And final, done and over, 30-15. There you go. There it is. The final score. Not only did Tennessee win, but Georgia won also. I was rooting for Tennessee to beat Alabama. That's awesome. Good job, Vols. Good job, Dogs. Man, oh man. Sorry, Texas. You just got unseated. Yes. Let's see where I'm going to send all you fine folks tonight. It's going to be a good night. It has always been a good night. Looks like MG is streaming tonight. He's doing some mother trucking. Aussie Overlords playing over there. You got a whole crew over there. And let's see who all we've got going on here. We've got MG, we've got Bruce from Oregon, IT Goatee, you got Tug, you got Flux. Let's see if Flux is streaming this tonight, then I will send you guys over to Flux because she needs to get some more subs. Let's see here. Let's see what we got going on. Show more. Let's see what we got going. Doesn't look like she's streaming tonight. It just looks like Fox and MG or Law are streaming tonight. So I'm going to send you guys over to MG. He's the smaller channel. Send that man some love. Give him some care. And I'm going to get his stream pulled up here. Make sure that you guys go and show that man some love. And let's go back in here. And because we're having fun tonight, and I will be streaming tomorrow. Make sure you come by tomorrow. Make sure you don't bail on me now because you got to come by tomorrow for the spicy chat. That's where we're going to have some fun. Spicy chat tomorrow is going to be a blast. we'll probably be finishing out TJ Finn's, and then we've got a little bit of stuff that we're going to be covering Monday morning is going to be a new week, but tomorrow is going to be a new bit of fun. So come by tomorrow, have a good time, y'all, and we'll see you on the end of this. Peace, y'all.
Working tight, I can't wait. You passed out, hoping you return my fate. Empty my stash out. Stupid game has turned to cruel. Are you feeling me? Love inside, I feel the fool. I can breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. Breathing stuff, I'm almost begging. Please. Drinks on God, don't leave me here. Lost my air in this year. In this case, I disappear. Are you there?